What you see in the background is the legendary Capitol Beltway.
Yeah.
For one of the rare times in recent years, I'm actually in my office at the National Science Foundation. So you can Zoom from anywhere.
Good to have you.
It's good to be here.
Hi, Shauna.
Hello, Shauna.
Hello, hello.
Janet.
Hi there.
Hi, Janet.
I might be muted. Good evening.
Hey, John.
Oh, hi. How are you?
Hi, John.
Oh, hi, Aaron.
Hello there.
Michael.
Holidays run. I don't think this is the holiday party, though.
Hi, Ron.
Evening. Hi.
Hi, Ron.
So I think we're still waiting for Elliot. Is that right, Aaron?
Yes, we're at 6:59. He may run late. But I believe he's trying to get here. Carol.
Okay, thanks. And Giselle is not attending, not able to attend. Right, okay. Here comes Elliot. Hi, Elliot.
Hello.
Great. Well, I think we're all here and it's 7 o'clock on the dot. Shall we get started, Aaron? I'd like to call the Planning and Zoning Commission meeting of December 15th, 2022 to order. We have 2 public hearings scheduled for this evening, so I want to take a few minutes to review the process for public hearings. During the public hearing, the applicant will be invited to join as a panelist to present the application, explaining to the commission and others present what is being requested. The applicant or staff will share all application materials on the screen as needed. Comments of town agencies will be read for each application if there are any, and there will be clarifying questions from the commissioners. Then there will be an opportunity for clarifying questions from attendees. Please raise your hand through the Zoom platform and wait to be called on and unmuted. The applicant, next, those who wish to support the application may come forward, and then those who oppose the application may come forward. As this public hearing must be recorded, it is necessary for speakers to identify themselves each time they speak by stating their name and address. The applicant will then have an opportunity to address any questions or concerns raised by the public and/or commissioners. Once the public hearing is closed, the applicant is free to leave or remain for the balance of the regular meeting, during which the commission will try to reach a decision on each application. Each applicant will be notified in writing as to the decision of this commission and has a right to appeal to Superior Court if desired. Decisions of this meeting are available the day after the meeting by calling the Land Use Department at 203-245-5631 after 9 a.m. All actions taken tonight by the commission will be by roll call. All commissioners and staff will identify themselves for the record before speaking. Seated this evening are members Ron Bodenson, John Duza, Shona Hay, Elliot Hitchcock, Janet Peckinpah, and myself, Carol Snow. I would also like to seat our alternates, Michael Bugda, in the absence of Commissioner Giselle Hagan, and Robert O'Connor to fill an additional vacancy. Staff present this evening is Aaron Mannix, Town Planner. This meeting is live streamed on YouTube and will be made available on the town website for viewing. Additionally, I would like to ask that we not use other devices unless needed for the meeting and treat each other respectfully throughout the meeting. And the Town Planner, Aaron, will now read the legal notice. Thank you.
Thank you, Madam Chair. The PDD text amendment is a continuation from an earlier legal notice. So there's no separate legal report for that application for this evening. But notice is hereby given that the Planning and Zoning Commission will hold a public hearing on Thursday, December 15th, 2022 at 7 p.m. via Zoom online webinar. Attendees may join the webinar through either the webinar link or call in information below. Our webinar ID is 915-8196-6735. Password is 452138. The following application will be heard: 21-19, regulation amendment, temporary moratorium extension, Applicant is the Madison Planning and Zoning Commission, Article 2.20.4, extend temporary moratorium on recreational cannabis establishments until July 1st, 2023. Further details on how to participate in the webinar are posted on the Town of Madison website, www.madisonct.org. Copies of these applications are available for inspection in the Land Use Office. All written correspondence can be submitted to the Land Use Department via email, at landuse@madisonct.org, or dial 203-245-5631 for assistance. Dated in Madison, Connecticut, this 21st day of November, 2022. Carol Snow, Chair. This was published once in the source on December 1st, 2022, and once on December 8th, 2020.
Thank you, Erin. We'll move right to our first agenda item then. Could I have a motion to continue the public hearing for 22-27? The applicant is Fraser Lulage, petition for regulation amendment to Madison zoning regulations, section 32, planned development district. Could I have a motion?
When you say to continue, I don't understand. Are we delaying it? Are we?
It's a
Moving forward.
continuation from our November 17th, 2022 meeting, Ron.
Okay, so, all right, so it's not another continuance.
Thanks, Erin. I think
Okay,
you're
I'll just,
to clarify for us.
Thank you.
all right,
Continued hearing, Ron.
all right, I just want to make sure. And Carol, another question. Are we, and I thought this came up before, are we able to seat someone not for a member who's unavailable, but you said you were seating someone for a vacancy? And
Yes,
I thought that was not permitted, but you and Aaron probably know better.
we've learned from our town council that it is actually permitted.
Okay, all right, that was contrary to prior advice. Okay, that's interesting. All right, thanks, just wanted to make sure.
Thanks. Okay, so could I have a motion to continue the public hearing from November 17th?
I'll move to continue the public hearing from November 17th.
Second?
I'll second.
Thank you, Elliot. Any further discussion? Not all in favor?
Aye.
All right, thank you. So we're inviting the applicants to present any information and updates. I see. We have attorney Jeffrey Beatty and Marjorie Shansky. Are you part of this as well?
She will be, Madam Chair.
Okay, great. Thanks.
Good evening. My name is Jeffrey Beatty. I'm an attorney in Guilford with the firm of Sullivan, Griffith and Beatty, 705 Boston Post Road in Guilford. And I'm the attorney for the applicant, Fraser Lulage. Just by way of background with regard to why we're here this evening, earlier this year, I had submitted on behalf of my client a proposed text amendment to allow to amend the regulations to allow the use of the property at 251 Boston Post Road, the Madison Winter Club, to be used as a restaurant following these by a special exception. Following a public hearing in May of this year, that text amendment failed by a 3-3 vote of this commission. Not because there was any, my take on it was not that the proposed use was objectionable to the members of the commission or the majority of the members of the commission, but because the procedure that we had submitted, the text amendment, wasn't the preferred way that the commission would like us to submit to amend the regulations to allow us to proceed with that proposed use. So we met with Ms. Mannix and Mr. DeLaura and discussed alternative methods that might be more appropriate to get this, to amend the regulations to allow my client to move forward with his proposed use of the property as a restaurant. The suggestion was made and we discussed amending section 32 of your regulations with regard to the planned development district. Since it was an already existing feature of the Madison Planning and Zoning regulations, that was felt that it was more appropriate to amend that. The problem that my client faced was that the property that we were interested in, the Winter Club, wouldn't fall within the categories that were within the regulations as they were written. So we prepared an amendment that expanded the number of the types of properties and the uses to allow my client's intended use of the property. During the course of the preparation of these amendments, we consulted with Attorney Shansky, my colleague, who's going to speak with you in a moment to give you the history leading up to the adoption of the planned development district, the mechanisms that were put in place at the time it was adopted in order to address any concerns that this commission may have or the public may have with regard to the intended and the intention and the adoption of the regulation and its use, how it's been implemented and how we're proposing it be implemented if this commission were to amend the regulations. So that's the background and why we're here this evening. It's a text amendment that will allow this commission to have greater discretion over the number of properties in town that may be suitable for the types of development contemplated by the planned development district already a part of your regulations. So with that, I'd like to turn it over to my colleague, Ms. Shansky, to give you some background as to how these regulations came into existence, how they've been applied, and why we're hopeful and confident that amending the regulations as we've requested would be of benefit to your commission, to my client, obviously, and to the town in general.
Thank you. Attorney Shansky, you're muted.
How polite of me. Good evening, Madam Chair, members of the Planning and Zoning Commission, many of you whom I have not met before. Hello. I am here because I was an author of the 2019 amendment to the Madison zoning regulations that created Section 32. I worked in close collaboration with the town planner, and obviously the commission adopted it. I represent clients who have availed themselves of the existing Section 32. We have one where the PDD has in fact been landed by the commission, and the other one is pending before you currently. So that is an interest that I have in this, but I want to also tell you that by way of background, I've been a practicing land use lawyer for 37 years. For the past 17 years, I've been teaching a course at the Yale School of the Environment, formerly the Yale School of Forestry, entitled Local Environmental Law and Land Use Planning. I've been teaching land use planning and a land use practicum at Quinnipiac Law School for the last 4 years. My students at Quinnipiac have interfaced with the town of Madison, providing over the years a tutorial on preparation of a natural resources inventory, providing research for the Coastal Resiliency Committee, and most recently, preparing a paper and guidance document for the Planning and Zoning Commission on the then recently adopted cannabis decriminalization legislation from the legislature. I consider myself to be a practitioner, an educator, and a student of land use law and planning, both of which are constantly evolving as the needs of communities and our environment change. So the importance of a planned development district is to overcome the rigidity of the Euclidean zoning system that has been in place for 100 years now. The Supreme Court decision, Euclid versus Ambler Realty, is from 1921. So we are a century into Euclidean zoning, the conventional zoning that regulates height, bulk, and use. And that has given us the gifts of Euclidean zoning, our urban sprawl and the uncontrolled consumption of green fields for development in the absence of population growth to support that development. But because of this segregation of uses that Euclidean zoning has fostered, that is the situation that it created. Planned development districts are a flexible zoning tool that can be used to combat that outcome. It is actually, contrary to some of the correspondence that the commission has received this evening, it can be a vehicle for way more environmentally sensitive development, because we lose the rigidity of the equal side yards, equal front yards, equal rear yards, and the 1 acre or whatever that is required for a lot area. So the Supreme Court of the state of Connecticut has recognized the legitimacy and desirability of the flexible zoning tool of planned development district, and it was in that spirit. And because your plan of conservation and development, which sitting here today is the same one pursuant to which we adopted this regulation, espouses certain values that are reflected through the mechanics of a planned development district, like diversifying the housing portfolio. As you know, Madison is 94% single-family housing on single lots. That is a tremendously environmentally excessive way to do landscape development, and a planned development district can counter that. I noticed in Attorney Ainsworth's letter that he makes some really hyperbolic statements as sort of, felt to me like attempting to instill fear in the commission, and I would like to sort of debunk his debunking of the, on page 4 of his letter, you still have feral control myth. His suggestion and his equating early in his letter of the planned development district to the small cluster development regulation is erroneous. The small cluster development regulation requires to implement it a special permit. That is a discretionary exercise before this commission, but in order to gain approval, you have to demonstrate conformity with each of the standards. In a planned development district, the first application is to remap the parcel and take it from its current map designation into PDD or planned development district. Unlike a special permit exercise, which goes to the administrative function of the commission, and let me interrupt myself and say, if you have questions about what I'm saying, please interrupt me and ask them, because I'm here to help. I'm not the government, but I'm here to help. So the exercise of a special permit goes to your administrative authority. If the standards are met, that's the scope of your discretion. In a legislative capacity, which is the adoption of a map amendment to planned development district, that goes to the commission's legislative authority, your lawmaking authority. It's the same as if somebody were coming to move their parcel from the commercial zoning district into the industrial zoning district. And it is the commission who has virtually unfettered discretion to determine whether or not that request is in the interest of the community as a whole. That's the standard. And whether it is consistent and reflective of the goals and policies of your plan of conservation and development, and not inconsistent with what is going on around the area sought to be remapped. So some of the assertions that are in counsel for the Land Conservation Trust letter, as I said, are hyperbolic. They admit of extremes, but at no time does a commission lose its authority under its legislative authority. You do not lose your discretion to say no. And people who have a right to take an appeal of that are largely disappointed at the courthouse door, because courts recognized and defer to the legislative discretion of a land use commission. So One of my purposes here this evening is to tell you how this regulation came to your regulation book, and to dispel concerns that you may have. I saw in some letter a suggestion that let's look at all the properties that the adoption of this text would affect. The adoption of this text will affect no property. It is just a text amendment. It is only after a petition is filed to remap a specific piece of property that there is the likelihood of effect, and that's only if you were to adopt it. So if you were to reject it on grounds that it was inconsistent with perhaps the surrounding neighborhood or not connected to infrastructure, whatever the legitimate planning-based, land-based reason were, that's your discretion. So the text is just a text. The amendment is limited to section 32.3.2D, 2i, the eligibility criteria. And while counsel for the land trust goes through those and criticizes each of them, they may not be pulled from the regulation meaningfully without then looking at the other standards pursuant to which the commission exercises its judgment in evaluating a petition. So the burden on an applicant is high. And as in everything that comes before this commission, an applicant has the burden of establishing its eligibility for the relief that it is seeking, including the amendment to the map of the town of Madison by the adoption of a planned development district. Planned development districts do not preempt the underlying zoning, which is another assertion in council's letter. They supplant it. They change the zone. That is a pretty garden variety event if the town adopts a map amendment. But we're not here tonight to talk about map amendments. We're here to talk about a text amendment that simply opens the door to a more robust potential application of planned development districts for the town of Madison that would yield a desirable alternative to the Euclidean construct that is pervasive through the regulations. I also want to say that the adoption of a planned development district does not leap over the Inland Wetlands Agency's jurisdictional review. That is unchanged. So all of the regulatory reviews to which any land use application is subject applies in this case as well. I feel as though I've said a lot, given you a lot of information in a short period of time, and I truly would be grateful for your questions.
Do any commissioners have questions for Attorney Shansky or Attorney Beatty at this point? Ron, you need to unmute.
So
This is Ron Bodenson.
as I understand it, you've been hired by the proponent to be sort of an expert, legal expert, to come here tonight to give us the historical background and your experience and your recommendation, or do you?
No,
No.
no.
So you are. So
I'm an
are you
amicus
the?
curiae. I'm an amicus curiae.
So you're just a friend. Yeah, you're just a friend to the court.
And I wrote the original regulation in the book.
Right. But the statement that more than one of the letters written by law professors, other attorneys, the chairman of the conservation, they're basically saying that this is a proposal backed by development attorneys, and you are one of those, notwithstanding your academic criteria. So how do I say this? You come touting your academic criteria as a friend of the court with no axe to grind, but you represent many developers in Madison, do you not? You appear to all fall in front of us.
Thank you for recognizing me.
Yeah, I remember you.
I represent developers, I represent environmental interveners, and the reason I am, or the tenet to which I subscribe is that I'm here to talk about the law, whether I'm representing a developer or representing an intervener.
Right. And I appreciate that. And there has been other lawyers submitted, but we're not lawyers. Aaron, have we been given a legal opinion by our town attorney, sort of weighing in on the debate between very expert and smart attorneys on opposite sides of this? Or are we just going to decide ourselves what the best legal argument is, as if we're judicial judges?
This is the first night of any discussions of the
Okay.
application, Ron. And so
Sure.
it would be this evening to listen to the presentation of the applicant. And if you have questions or your comments from the public or questions of staff, including your legal counsel, then the commission can decide to request additional information. But
Okay.
at this time, it's not customary that we typically come prepared to a hearing with a legal argument from or reasonings from our land use attorney, unless that's specifically requested by the commission. I do have some, I'll let you finish if you have more questions.
Yeah. The only other thing, Counselor, is what you're saying is that what this is doing is increasing the eligibility criteria and taking it out of the Euclidean zoning requirements and all. But there's a reason for there being eligibility criteria. So there's not any chance at all that an industrial park is going to be put in the next to 3 housing developments. I mean, there's reasons, there are categories, and so the argument that let's expand the eligibility criteria and then just simply rely on the planning and zoning committee to do the right thing in the future, that's really not the way the system works. We have zoning categories that prevent us from doing stupid things.
There are zoning categories in this regulation. There are use restrictions in this regulations, and I
just deciding what Madison is going to look like no matter what. So my point is, there are reasons for criteria, and
There
you're
are
saying, oh, just
criteria.
eliminate the criteria and you all decide what you want to do.
It's not an elimination of criteria. If you look at section
Well-
32, which is a multi-page document, it's full of standards. It's full of standards.
Yeah.
They're the standards of the planned development district. And if I
Well, I
may.
was using
just-
your words.
Pardon me?
I was using your words. You're saying you're expanding the eligibility criteria. So we must be eliminating a lot of eligibility criteria. So now we can do things
No.
we couldn't do before, which
No.
may be a good idea, but
Think-
it's not the way the entire zoning system works.
Thank you for that question, because that
Yeah.
leads to a very critical clarification. Currently, section 32.3.2D, let me find it in my book here, has only one parameter for an eligible location. Well, I guess there are 2. They have to be located either in the R or R2 zoning district, and they have to be located within an area specifically designated as a future development opportunity in the 2013 POCD or a successor document. And indeed, the 2019 adoption of section 32, which I encourage everybody to read, was limited to 2 areas, 1 area really, in the town of Madison, that both in the residential section and in the business section of the Plan of Conservation and Development were identified as future development opportunities. And on the same page of the POCD, it invokes the notion that plan development districts might be an appropriate vehicle for those areas. So there was a very tight relationship between what the POCD says and what the regulation says in 2019. And the commission adopted it. And you have approved one remapping and you have another one pending in front of you under those criteria, totally reflective of the POCD. Then in December, and I'm sure there must have been something in between, but I don't work at town hall, so I don't have a day-to-day sort of movement on it. December 3rd, 2020, at a meeting of this commission, according to the minutes, this commission with the town planner went through 10, 12 properties in town and talked about each of them as being a potential for a planned development district. And sometimes the underlying facts were that the prior use is no longer functioning. It's a property that is eligible for adaptive reuse and restoring to the tax rolls, or it may be, we'll get right to the sort of controversial issue, the issue of land that is currently or historically farmland. Well, with respect, so the objective of section 32.3.2 D2 is to add new categories of eligibility. There's still all of the other standards of section 32 that have to be met to be qualified for a PDD. There still has to be consistency with the comprehensive plan and the plan of conservation and development. So the kind of incongruity to which you're referring and to which the letters have referred is not likely. I would like to impute to my brothers and sisters in the law that they're not going to not be vocal if their clients are attempting to do something totally unapprovable or untoward or incongruent. That's why we have advisors. And at the end of the day, it is this commission that exercises its mighty authority to say it doesn't work, that doesn't work, and it doesn't work there. So you are the final word on it. Madam Chair?
Yes, I have a question for you to follow up on that. Under section 32.2, the statement of purpose, it mentions diversifying housing and also encouraging open space. So could you explain how the change in language complies with encouraging open space?
There's an open space requirement in any residential development under the PDD regulation. So it is a de facto.
So it's within the planned development district that open space is encouraged.
Correct. Or
as opposed to
required.
Outside of that one district encouraging open space and not, impeding on open space.
Right. And though I don't want to get distracted, some of the correspondence suggested, oh, it's imperiling parkland. No, there's other legislation on the books. You can't get rid of parkland unless, of course, you replace parkland, which is a municipal function and an onerous thing and very rare to happen. But there could be town-owned properties that are not dedicated parks that might be eligible for reuse at some place along the line. So again, this is just a text amendment that doesn't deprive the commission of any of its power.
Are there any other questions from commissioners?
There was maybe one other thing, Madam Chair, and I beg your pardon, that I would like to say perhaps for the newer commissioners, and I apologize if you're like way ahead of this, but a planned development district process is a two-step process. It starts with a petition and a master plan to rezone a parcel. And you have to show enough of what you're intending to do to ascertain compatibility, conformity with the environs, harmoniousness with the existing landscape. Traffic information is required. Some of the similar kinds of information that would be required in the special permitting. And it's only after that master plan has been adopted that we move to detailed plan review. That goes to the administrative function of the agency, but part of the part of the underpinnings of why it's a two-step process is because we don't want to have an applicant engage in full engineering if the map is not going to be accepted. So there's rational thinking behind it. It has an efficiency associated with it. And the other thing that is an element in the Plan Development District regulation is a pre-application meeting. So before I even file the petition to change the map, I come to the commission and show them what we're thinking, which is a wonderful time to say, you want to do what? And refocus what an applicant may be planning, because at the end of the day, this wants to wind up being something which, consistent with the law, is in the interests of the community as a whole.
Thank you. If there are no other questions or comments from the commissioners, I think we should open it up to the public.
Yeah, I have one, Carol. This is probably shows my total naivete, but it seems to me that what you want is to operate a restaurant at the Winter Club or on that property. But it seems to me that you're asking for something that's much broader in the land area that this PDT would entail. What am I not understanding here?
We are looking to amend the regulations to allow the use of the Winter Club, but the thought was, rather than have us come for a narrow expansion of the text, or a revision of the amendment of the text amendment to allow just that use, that there were other properties that the commission had discussed in December of 2020 to try and incorporate, or to give the commission an opportunity to say, yeah, we had to discuss those, and this is an opportunity for us to amend the regulations to allow us to consider properties other than the Winter Club, again, retaining that legislative authority with the submission of the master plan. So you could look to see if somebody came with an application on another location, whether or not it was appropriate for that site, for the overall comprehensive plan of, if it was compatible with the comprehensive plan of development, and if it was something that worked well within that neighborhood, rather than have another person or another property owner come in like we are this evening for one specific property. The concept was, throughout the discussions that we'd had with town staff, that we would broaden the terms so that other properties that would fall within the criteria that we've proposed were eligible to come before the commission for its review.
And also along those lines, maybe, Robert, to explain a little bit, this is being proposed, as I understand it, as an interim proposal. Aaron, maybe you could talk about the process and why it's interim.
Well, I think as Attorney Beatty has indicated, the additional language that was added to try and address pick up that conversation from the December 2020 opportunity areas is an interim fix, in the sense that at some point after our plan of conservation and development, the commission is going to do hopefully a comprehensive overview and review and rewrite of the zoning regulations, more for readability, organization, and then being able to adapt to some other goals that come forward during this POCD process. So I think it's interim in that sense, where I think, to pick up on the values of this PDD concept as a tool, I do think there are, and it's clear that there are properties, whether they are vacant properties currently, or non-conforming properties, or underdeveloped properties that may serve or may be able to be redeveloped in a way that is not necessarily within the existing zoning regulations, but in harmony with the surrounding area, whether that's to produce housing diversity, as we've identified the need for in our affordable housing plan, or for mixed development, additional resources in other areas of town and amenities in other areas of town.
And just to clarify, Aaron, I want to say that we're just beginning the process of updating the 2013 Plan of Conservation and Development, which we aim to complete by the end of next year, so that it's a mandatory 10-year update.
And one last, and I know we've had over the last several months, we've had some new commissioners join us, and so some of you were not present during the last text amendment application, where Attorney Beatty came before you, where I provided in my staff report your legislative powers and responsibilities in considering a text amendment. So I do have that information. I know Attorney Shansky touched on that a bit. I want to make sure that especially our newer commissioners understand that responsibility, or if you have questions or want me to read through that process again for you, I have that available, as well as the explanation of the PDD regulation, how it exists today. And that was, we did also, I'm not sure we had everybody here for that as well, although it was in the nearer past. In my staff report, walked through what the process of a PDD is, considerations that the commission has. So I have, I've copied and pasted this information from both of these staff reports. It may not be new to some of our older commissioners, but if you feel it useful, I'm happy to go over that with you step by step now before we have public comment come in as well. If you just have general questions. I know sometimes, as we are a new group and continue to refill our full constituency here of members, we sometimes need to pause and just bring everybody else up to speed. So I'm happy to do that. If you feel like you've missed something or have additional questions, please let me know.
Well, Aaron, I have a question for you. So,
Yes.
so related to the summer decision. So my reading on the background was that the commissioners who voted against the application generally liked the idea of the restaurant taking the place, but they were concerned about the possibility of that specific restaurant and this particular applicant might not succeed there. And my question is, this new avenue, which seems a little more ambitious and elaborate, how does that address that concern, or does it?
So as Attorney Shansky indicated and Attorney Beatty, this is not an application for a specific use on the Winter Club property at 251 Boston Post Road. What this is it is a general text amendment that these new criteria that are added in addition to existing criteria for eligibility for a PDD, expand the landscape areas where applicants can apply for the PDD. Specifically regarding the application this summer, it was a text amendment requesting that the zoning regulations, which I believe was the residential or residential section, to be amended to allow site specifically at this particular property a restaurant on the site. Now, the reason that application was denied was because the proposal was not consistent with the uniformity provisions of the statutes that require a level of consistency throughout the district. So in the district was a residential zone, and so applying that particular restaurant use on one parcel within that district was not consistent. The statutes state all such regulations shall be uniform for each class or kind of buildings, structures, or use of land throughout each district, but the regulations in one district may differ from those in another district. But note that floating zones and other overlay zones constitute this exception to the uniformity requirement. And as Attorney Shansky indicated, Supreme Court has upheld the creation of zoning districts as a planned development district, as they're found to be similar to the creation of a floating zone. This is significant for municipalities for the discretion allowed in the creation of these floating zones, and the approval of specific uses within them may not otherwise be available in the underlying district. So that was the reason the application was denied, was more for the proper process and
Okay.
following the language of the statute. Does that make sense?
Sure, thank you.
You're welcome. Any other questions from commissioners? You can ask them again later, but we can move to allow for comments as well from the public if you're ready. Okay.
I think we're ready.
Okay, so we would just ask all our attendees, anyone who is interested in speaking on the record, to please raise your hand virtually here, and we'll call on you, allow you to speak. Just please identify yourself for the record.
Just to clarify, are we going to allow people to speak or ask questions? Is this the part where they should be asking questions or talking in favor or against? Usually separated.
Want to go? We can go questions first. So if anyone has a question, sorry to make you raise and lower your hands, but if you have a specific question that you would like to ask the applicant, please raise your hand, and then we will then allow for an opportunity for those to speak in favor of the application and those to speak in opposition of the application. But at this point, please limit your comments to questions. So first, we'll have Keith Ainsworth. Keith, if you unmute yourself and identify for the record.
Yes, good evening, ladies and gentlemen. I actually don't have questions. I have comments. I came here for public comment. So if you want me to ask questions, I will defer and let someone else ask questions until the comment period comes in.
Okay, well, we have one other individual with their hand raised. So if that's a question, we'll then circle back for comments after that. Okay?
Thank you. That sounds fair.
Thank you. Okay, next I have Joseph Mako. Joseph, you could identify yourself for the record and
My name is Joseph Mako. I live at 22 Randy Drive, and I've been a resident of Madison for 50 years. So can Attorney Shansky please expand? She said a number of times, this is only a text amendment. Well, I mean, what other kind of amendment would there be? I mean, aren't these amendments all put down in text? So can you clarify what's a text amendment? And the other question I have for you also in your comments, do you deplore the way Madison was developed? Because I've lived here 50 years and the majority of people that live here love this town, and we don't want to see you ruin it. Thank you.
Shall I answer that, Madam Chair?
Yes, please. Thank you.
This is Marjorie Shansky for the record. A text amendment simply enters the zoning regulations as among the many possibilities that an applicant can trigger to attempt a development. It does not apply, as Ms. Mannix described, it is a kind of floating zone. So there are, by definition, no planned development districts until a separate petition to land the planned development district with a map amendment. The map amendment creates a physical change on the zoning map, but the text amendment simply adds the possibility to the regulations of seeking a different kind of zoning relief. I hope that was clarifying.
Are there any other questions at this time? James Norgren, if you could identify yourself for the record. You have a question? James, are you able to speak? I think his microphone may not be working. Hey, James, I'm going to give you a minute to get your microphone working and jump down to our next question while you're working on that. I have Wendy Sean, if you could identify yourself for the record.
My name is Wendy Schoen. I live at 194 Bartlett Drive. Attorney Beatty said that, as I understood it, he said that he wanted to change all this wording so that the town could have things in the future to make it easier for things to happen in the future that were not related to the Winter Club. So I'm just wondering, what did you have in mind? Why do you care?
I don't have anything in mind other than the Winter Club. The idea of the text amendment was, as Ms. Mannix indicated earlier, was that this is going to be an interim amendment because the revision of the plan of conservation and development was about to commence, along with a revision of the planning and zoning regulations that was being contemplated by the Planning and Zoning Commission. So the thought was, rather than come with kind of piecemeal text amendments while the Planning and Zoning Commission was doing taking steps to address those two items, we would come up with a more, for lack of a better phrase, comprehensive interim amendment that would allow people to come forward with plans to submit them to for a planned development district that would allow the Planning and Zoning Commission to consider them while it was doing the same work, while it was doing the simultaneous work of reviewing its plan of conservation and development and amending its regulations. So I had proposed a text amendment earlier this year that was site specific, and I suppose I could have proposed a text amendment that was similarly site specific, relating to the amendment to the Planned Development District regulations. But the sense I got from speaking with the folks at Town Hall was that it might be better to present it this way so that the commission wouldn't have to consider similar multiple. I don't know how many other people may come before it with a similar application, but rather than have the commission consider it on a case-by-case basis with regard to amending section 32 multiple times, we could try and do it in a way that allow the commission to consider properties that were previously identified as potential sites for development without having to amend section 32 multiple times. So that was the concept behind it. Not because I'm aware of any other development projects or advocating for them.
Madam Chair?
Yes, Attorney Shansky.
Yes, I'm sorry. I want to just add to Attorney Beatty's last comment because the addition of a broader eligibility constituency is reflective of the action of the Planning and Zoning Commission reflected in the December 3rd, 2020 minutes. So it's simply a reflection of that. It's not authored, or the genesis of it doesn't come from any outward source. It's from inside your own minutes and the work of this commission.
Thank you. Are there any other questions?
Yes, Madam Chair. Ann Tarpey Flanders. You could unmute and identify yourself, please.
Sure. Hi, everybody. Ann Tarpey Flanders, 94 Five Fields Road. I'm sort of new to the party and I'm trying to grasp what the issues are. And thank you so much for everything that's been explained so far. It seems to me that the issue of land development, preserving open spaces, and the character of Madison is of concern to a lot of people. And I'm wondering if the commission has considered, and perhaps you've already done it and I missed it, I don't know, but has the commission considered maybe doing some public education on really what this is all about? I just think it would be very helpful for a lot of people to understand this a little more fully. So that's my question. Have you considered that?
Thank you for that question. I think this public hearing is our effort to do that.
Yeah.
I don't know if anyone else wants to add anything to that. Okay, thank you. I see hands up. I don't know if there are questions.
Norgren. Margaret, if you could unmute yourself and identify yourself for the record, please.
Hi, I'm Margaret Norgren. My husband, Jim, was just trying to speak. So we have the same question. It may have been asked already while we were trying to deal with our technology, but what we support the Winter Club becoming the restaurant. We don't understand why the text amendment couldn't be much more narrow to approve the restaurant without broadening all the other, making available all sorts of possible other development projects.
Thank you.
I don't know. I thought I had answered that the last question. I'm happy to, reiterate it if necessary. I leave it up to the chairman, but my explanation was that we didn't want to create a situation where the commission was kind of tackling this bit by bit while it was doing its plan of conservation and development, revising its regulations. And as Attorney Shansky noted, it was designed to kind of capture those properties that the commission had identified in its December 2020 meeting, so that they'd be eligible for consideration should any of those property owners decide that they wanted to apply for a planned development district designation for those properties.
Attorney Shansky, did you want to add to that?
No, thank you.
I think maybe another way of asking it, the question is, and maybe this will come up from the public too, is how these different categories were established and compiled for this proposed amendment.
Madam Chair, this is Attorney Shansky. Directly from the December 3rd, 2020 minutes. They are descriptors of the properties in the list enumerated by the commission.
Thank you.
But Madam Chairman, none of us have a copy of those minutes. A year ago, I'm not disputing them, but my memory is we talked about 10 properties or so, but I don't recall it being related to plan use development. There's another phrase like that David Anderson used that was in the minutes all the time about.
I think it was transition zone.
Yeah, well, it wasn't transition. Maybe Aaron, who must be familiar with the December 20 minutes, but we spent a year talking about these are sort of like, let's promote these properties as possible development properties in Madison. They're just sitting there, and maybe these are 10 we ought to think about. I don't think it was focused necessarily on planned development under this section, but Aaron could maybe correct us. None of us have the December 3 minutes in front of us. I don't think it was part of what was submitted. And Aaron, I haven't received it in the last week. So what was the other phrase, Aaron? What was Dave Anderson hitting us over the head about for a year?
I can share those if with you. These are the planning and zoning minutes from
No,
December 3rd.
opportunity areas. That's what it was. It's opportunity areas. So,
Discussion
but you're
regarding-
right. It was PDD. All
It
right,
is
for sure.
relevant
Got
to
it.
the
Okay.
PPD, yes.
Got it. Okay. So I couldn't remember the phrase, so I wasn't sure it was actually PDD. So I think they are correct that it was PDD. Some reason that
honestly,
phrase got dropped. Yeah.
Ron, and the way that left, and I will submit my staff notes for the record here in the hearing, which I will include these minutes in the record as well that we're referencing here today. Basically, so as you can see, there are various bullets of varying properties, some of which are legally non-conforming properties, some were former school properties, privately owned properties, and just coming to the end here, as far as what happened in this particular situation, it was determined some of the properties specifically had notes, leave on this list. It's not a list. It was clear it's not a list of recommendations, just opportunities. And this was an open discussion with the commission at the time. And the plan was, after discussing this at the December 3rd, 2020 meeting, to have the director of planning revise the list, send it to the commissioners so that discussions could resume in forthcoming meetings. However, as you'll look at the timing, COVID hit shortly after, and shortly after that, the director of planning resigned, and we had a transition in staff, and that conversation has never come back up at this point. And so in light of the request of Attorney Beatty's representing his client for that proposal at the Winter Club, and the thought process that a PDD concept would be more appropriate, it is included in that opportunity areas of this of these minutes that were discussed by the commission. This seemed like a timely, an appropriate time to open this, discussion again, and perhaps include varying language that could pull in some of these opportunity areas before further, discussion occurs. So that's kind of where the basis of this other language came from.
Thank you, Aaron. It's really helpful to see the minutes, and especially because many of us on the commission now were not on the commission then. So we appreciate that.
So these will, and I guess this is more in the interest of time. If the commission wants to go through these this evening, item by item, if you'd like to gather this information and then digest that for further discussions, those are things that you need to consider this evening. And just the information that's presented to you, whether or not you've had time to consider all of the information prior to decision making. As you know, in a public hearing, you can hold your hearing open statutorily. So there's no obligation to close the hearing this evening. That being said, let's see. We have additional questions from the public if we're ready to move on. Okay. I have S. Bischoff. You could identify yourself.
Hi. Aaron, actually, it's Jane Scenario. My computer wasn't working properly, so you couldn't hear me. So I ran downstairs to my husband's computer. I live at 852 Boston Post Road and been a resident of Madison since 2019, so relatively new. I just, want to make a statement and then ask a question of the commission. This proposal to me sounds like a very broad swath of zoning change. Okay, and therefore, in reference to what was mentioned earlier by one of my Madison neighbors, the case of transparency in education, I think, is really important. So my question is, would the commission please request a mapping of all the properties that would be potentially affected by this change? And I think it's so important to do this in making a case for transparency so that all the community members will be enlightened as to the potential change potentially occurring all around them. Thank you. And thank you to the commission for all their hard work.
Thank you. And thank you for that comment and question, I guess. Any other questions, or we can also move on to comments?
Yes, I have Matt Bennett.
Hi, good evening. Can you hear me okay?
Yes.
Yes, thank you.
Hi, good evening. It's Matthew Bennett at 917 Boston Post Road. I appreciate the dialogue and the earlier commentary around the objectives from the applicant. I guess my question probably be best directed to Attorney Shansky. If I'm correct that you're here as an amicus curiae, could you help us just kind of enumerate the pros? We've understood those a bit, but also objectively the cons that the commission and the public should have in mind as we contemplate, the decision ahead of us here. And are there kind of material risks, downsides, trade-offs that should be equally important to have in mind here on an objective basis relative to the pros that have been discussed throughout the hearing thus far? Thank you.
Attorney Shansky.
This is Attorney Marjorie Shansky, and that's a big question to ask for a spontaneous answer. I would like to be thoughtful in its scope, but I would say this, that the safeguard associated with the Plan Development District is that it is the legislative authority of the commission. And so just as I've suggested to the commission that there are no affected properties by virtue of the mere adoption of a text amendment, the idea that there is a downside risk associated with the adoption of the text, pardon me, easy for me to say, is that a commission is not, you have to trust the commission to use its authority with good judgment. That's why they're seated on the commission. And this is a process that's been in effect in Connecticut for decades. So I don't have an immediate downside risk to daylight. I will reflect on this question, but I do think that the inherent safeguard is that it goes to the commission's legislative authority, which is the hardest nut to crack. You can say no for a good reason or a bad reason, but not an arbitrary reason.
I don't see any other hands raised for questions, Madam Chair. Oh, I apologize, I do. Just keep popping up.
Oh. The hand just appeared. Oh,
It just
no,
disappeared. Just making me look silly now. Okay.
I'm following you with you.
I have Craig Chatfield. Craig, if you could identify yourself for the record, please.
We're at 10 Chestnut Hill Road here in Madison. I'm hearing Attorney Shansky saying, trust us, we know what we're doing, and everything will be fine. Is that correct?
Is that your question?
That's my question.
Okay, thank you.
This is Marjorie Shansky. I'm not expressing it exactly that way. What I am saying is that the legislative authority of a commission is broad and virtually unfettered, and that judges defer to the commission who is on the ground with their closest to the action when they make judgments. And so, yes, I think that that is the process, and that the legislative authority is broad and deep.
Kayla Friedenberg. Kayla, if you could identify yourself for the record, please.
Yep, Kayla Friedenberg. I live in Madison at 516 Horse Pond Road. So this has been a fascinating conversation. I have my question is, you know, we've heard that the PDD was enacted in 2019 and that Attorney Shansky was the author of it. And then we are also hearing that there's going to be a comprehensive revision of the Plan of Conservation and Development, as well as the zoning laws and P&Z and tidying up language and what you said, Aaron. So I guess my question is twofold. First, if we're going to be having this comprehensive look and at the regulations, as well as redoing the Plan of Conservation and Development, it's not clear to me why we need this pretty robust interim text amendment. And I guess my second question is, given that Attorney Shansky has, has said that she authored the PDD and, is authoring this text amendment, I guess my question also is, how, it seems like we're having different people from different walks of life, I guess, being invited to help write these regulations. And I guess as a resident of the town, I don't know, it would be nice to get some clarity on how the town goes about asking people to help them rewrite these regulations. Thank you.
Thank you, Kayla. So I can respond for one letter, unless Marjorie, do you have a response?
Marjorie Shansky, for the record, I do not believe I am the author of the amendment. I participated on the reviewing sort of committee, but I don't believe I am the author of the amendment. And under statute, anybody is permitted to provide an amendment for a commission's consideration. And as I said at the outset, this was done with the town at the request of the town and reflected in the Plan of Conservation and Development as a goal of the town. So, so it's just the organic unfolding of that sequence that resulted in the regulation that was adopted by the commission.
And if I could just follow up on that, the initial application that I made earlier this year, limited just to the Winter Club site, was a proposed text amendment. And so anyone who wants to submit a text amendment to the Planning and Zoning Commission, attorney, layman, whatever, has the ability to do so. The idea is that ultimately, if somebody thinks that there's a change that needs to be made to the zoning regulations, they can craft an amendment, submit it to the Planning and Zoning Commission for its consideration. And ultimately, again, the Planning and Zoning Commission will be acting in its legislative capacity at that point. We'll decide whether or not to adopt that amendment, to adopt it with modifications, or to deny it. So that's true, not just with Madison, but with any town's zoning regulations.
And this is Marjorie Shansky. I'd like to jump onto that because Attorney Beatty said something very important there. He said modifications. The text that's sitting in front of the commission is eligible to change over the course of this public hearing. That is the nature of why we have public hearings. So it is not etched in stone. And if there becomes a more efficient or descriptive or more desirable way to express the commission's will in the amendment, then it can be modified over the course of this hearing.
Thank you.
Thank you. Those actually, the process was what I was going to answer for you, Kayla. Did that answer your questions?
In part, I guess I would say that at the beginning of the public hearing, Attorney Shansky said she was the author of the PDD from 2019. So perhaps I misheard that. And I guess the first question I had maybe is for you, Aaron, or the commission is, and maybe it's just a thought question, is to come back and think about why we would want to add this fairly robust text amendment now when there are more comprehensive dealings with the Plan of Conservation and Development and these regulations coming up in less than a year. And that's all.
Thank you, Kayla. Yes, you're correct that Marjorie drafted the original regulation that was adopted by the commission in 2019. However, she did not author this specific language of the amendment. I think that was the clarification that.
This is Marjorie Shansky. I would say further that I sat in that conference room or the hearing room immediately off of the land use office and with Dave Anderson and worked on this regulation together. Yes, I authored it, but I was not alone in a room.
And if I would just tack onto that, and ultimately, although Attorney Shansky may have authored it, it was the Planning and Zoning Commission that adopted it and made the determination that those were the regulations that they wanted to enact with regard to creating a planned development district. The same way that it will consider the amendment that I drafted that's before it this evening when deciding whether or not to grant it, modify it, or deny it.
Can I ask a clarification? I thought Attorney Shansky said that she was not on the committee that drafted this. She just worked with him or talked to him. Attorney Beatty says he drafted it. Is there a committee of development attorneys who sat down and drafted this? Or are you really saying you're the only one who touched it along with apparently our land use planner is the one who maybe, I thought you said she suggested you expanded it the way it is.
Mr. Bodenson, this is Marjorie Shansky.
Yeah.
You're conflating the original, the original regulation with the amendment.
Well, which one had a committee? Because you just referred that you didn't draft it. You were just on reviewing. You were helping to review in committee. You just referred to a committee of people who drafted it.
Yeah, ad hoc. We just looked at it with the town planner and with Mr.
All right.
Beatty.
Well, who are, Aaron, can you reveal who it is you've been meeting with? And they've all said that you are the one who suggested that they expand it beyond just the Winter Club. We don't know who these people are. Could we now just find out who they are?
Okay, Ron, so initially following the denial of the text amendment by the commission, I met with John DeLaura and Jeff Beatty to discuss the possibility of amending the PDD. In doing that, in the conversations, attorney Marjorie Shansky was involved in that process because of her history of the original adoption, since I was not here at that time as well. And then also for the discussion of the 2020 minutes, knowing that the commission had already identified that there may be other opportunity areas. When you look at the existing document, it applies, it's an entire section for this tool that applies to 2 properties in town. And that's fairly narrow from a planning perspective. And that was the goal of the document at the time. However, and through various discussions with the commission, other opportunity properties were identified, properties that may have closed, properties that, may be looking to sell, things of that nature, and looking at opportunities. So that opened up the door for expanding criteria. In my experience in other municipalities, the criteria was broader. That's always been a question of mine, why we applied this to so specifically to 2 properties. And so, yes, I meet with most applicants, in preparing applications for the commission and discussing options and looking at feasibilities of properties. That's part of my role. And another attorney who was involved in discussing that was attorney Chris McKeon, as a land use attorney in town. So that was the extent of conversation with this proposed language, and the verbiage that may tie in some of these other opportunity areas. Because as you look through the list or you look through those minutes, the use of some of these properties are changing or maybe for sale or things of that nature. So in anticipation of seeing future applications, that was really the goal, was to try to look at this at one point rather than 3 different times, for amendments to this section. However, as Attorney Shansky and Attorney Beatty have indicated, this is, this proposal before you can be modified and looked at. So that's, and I think that speaks to the question of that Kay Aloha had indicated, as well as, that's the role of the commission to determine the extent of this change and the appropriateness of this change. So as you're reading through this information, you're going to have to make those decisions and come up with your findings.
I appreciate it. I just think it would have been fair and helpful to the commission at the beginning if you would have disclosed that you helped draft this with 3 attorneys who are generally viewed as developer attorneys. That's not a pejorative term. They're very competent. We've loved hearing from them over the years. But I just think we didn't know that was the origin of it. The 3, what I call competent developer attorneys, and you put this together. I don't think we would have known that, except she referred to a committee we didn't have any idea about. So
I would refer to attorneys as land use attorneys.
Yeah, well,
so
true, but
work with many land use attorneys.
Well, let me ask Ms. I think Ms. Shansky was the author of the first one. She said there was only one property that's been developed under the amendment. Was she the attorney for that developer?
It's not.
Yes. Okay. So that's sort of the way it works. If you get a text amendment, then it may be for a future or an intended client you're thinking about. It's not just, people just don't do it out of thin air. She drafted a very good amendment, and she had the only property and developer in town who made use of it so far. That's all I'm saying. Nothing wrong with it.
Property is the PDD regulation currently identifies 2 parcels, and it's on New Road, the north and south side properties at the intersection of Duck Hole. And as you recall, the commission just recently approved that map amendment for the south side parcel. And there is a current application that will be moving forward for public hearing for a map amendment to apply that PDD layer to the northern property of that original regulation. So
and the town or somebody just did the brilliant restriping of that intersection as they proposed, which should have been done 20 years ago, but thank you.
It's really good, isn't it?
That was
that's really good. That's really good.
Change is slow.
Madam Chair, Marjorie Shansky, I want to say that but what inspired there being a draft for a PDD amendment for the town of Madison is the fact that the 2013 Plan of Conservation and Development in both the residential and business section is explicit and mapped the new road parcels as development opportunities in the context of a PDD. So that doesn't come from whole cloth. That comes from your document, which is in a broad sense an invitation to implement your plan through the development process. And that's what that attempts to do.
Good.
I also want to say, before I relinquish my saying, is that the floating zone is not exotic. You have them in section 26 of your regulations. The Affordable Housing District is a floating zone. Section 26A, the Housing Opportunity District, is a floating zone. Section 27, the Open Space Conservation District, is a floating zone. So I want you to be comfortable in the notion that we're not doing anything here that you are not familiar with from an administrative perspective and can perhaps take some support by reviewing the regulations as they exist. Thank you.
Thank you, Attorney Shansky. Erin, more questions or?
I have CM32. If you could identify yourself for the record. Question.
Yes, this is Carolyn, Missouri. I live at 934 Boston Post Road in Madison. I want to first thank the commission for having this opportunity to listen to the questions and the discussion. And I understand very clearly that there's an administrative process that's being followed quite correctly. The comment I'd like to make, really, in being familiar with the original amendment of 2019, having read the proposed amendment, and also being familiar with recent development in my area, I really believe that this text amendment comes from outside Madison as a Trojan horse. It is not benign, as suggested. Rather, it opens the gates, in my view, to development unwanted by the community. This is evidenced, again, from my perspective, by community members now that I am aware of, and some of whom might be on this call. I know at least one who is, having sought assistance from Town Hall to close loopholes and narrow the original amendment. And this stems from seeing the result of the most recent plan development. That is the direct result of the currently existing less restrictive amendment. Further, I think it's unfair to state that the community should trust the commission. This is another misleading statement. We do trust the commission. We are the commission in essence, because we're part of the community, as are the commission members. But neither the commission nor the town planner can, as carefully as needed, know how the actual implementation of the plan will appear. And the evidence for that is the current development on the corner of East Wharf and Boston Post Road. It's impossible to make it look exactly as imagined. And I would really question areas of open space, and I would question other areas that have been mentioned. But I just want to conclude with one other thing that was raised. The First Amendment, apparently, according to what Attorney Shansky indicated, was written in 2019 based on a 2013 coastal resilience plan, so a 6-year-old plan. And now we're being asked for yet another amendment before the 2023 plan comes forward. Is there no consideration really about how the environment is changing so dramatically, and that we have to forestall these kinds of amendments at least until we have the 2023 Coastal Reserve Plan, so that we can make more intelligent, environmentally sound decisions? So I would ask the commission to consider all those elements. Thank you.
Okay, thank you. Aaron, I think Keith Ainsworth has been waiting patiently.
Good evening. I assume everyone can hear me.
Yes.
It's interesting. I feel like I've been relegated to the kids' table
Sorry.
at Thanksgiving. Attorney Shansky, who doesn't represent anybody, is an amicus curiae to the commission, whatever that is. That's a new role. I'm representing actually the Madison Land Trust. I'm a Madison resident and taxpayer. I'm also a fairly experienced land use attorney. I wasn't invited to the little party in the town planner's office. Apparently, I'm not recognized in the same category as Attorney Shansky and Attorney McKeon and Mr. Beatty. But I don't take offense. But I would ask the question, who appointed that committee? And I say that somewhat rhetorically. But the legitimate question is, who do they represent? Who paid for their participation? And what expectation do they have as a result of this promotion? Because while Attorney Shansky is an academic, I don't think this was just an academic exercise. She has a very active paid practice that is very active in town. And certainly Attorney McKeon, I don't believe teaches classes. So he has a very active practice in town. So why was this of interest to him? And so who do they represent? I think that's a relevant question. And I'm not casting stones here, but I'm saying we need to know where this comes from in order to understand what might be the ultimate goal. Because when you change a text amendment, it's a very broad tool. Now, when we talk about PDDs, they're not illegal. They're just a very potent tool. And you have to use them very carefully. They're like an explosive. You can blast a piece of rock that you want to move, or you can destroy things with it. It is very, very potent. The reason why developers like them, and here is probably one of the greatest concerns I have as someone who has represented interveners for decades, is that currently under our current Euclidean zoning system, there are three parties at the table. There's the commission, there's the applicant, and then there's those neighbors and pesky interveners. And what a PDD does is it's somewhat insidious. It gives all of the power to the commission. And because you have unfettered discretion, as Attorney Shansky said, to pass the map change, which is a legislative thing, that can't effectively be appealed. So suddenly your neighbors are powerless who have a direct interest to appeal. But then if you pass that and it can't be appealed, then the applicant comes in with their compliant PDD application. If they apply and they are and they are compliant, you have to pass it. And again, not appealable because they complied with the reg that you passed specifically for that PDD. In other words, the insidious part of PDDs, and the reason why developers love them, is not because they correct the abuses of Euclidean zoning. It basically takes interveners out of the picture because they can participate, but they can never go to a court and ask for a review. I've experienced it myself. I've been in that position where I've seen this process take place. That's the danger of a PDD. It's perfectly legal. The Supreme Court said you can do it, but it does say that everyone has to trust the commission. And this commission is fairly new. If you remembered, not that long ago, we had a commission that was basically running freight trains through this town. If an application came in, they had a lot of fun with the small cluster development and shutting people down by tweaking it just so it fit for the developer. And it was custom tailor-made stuff that was going on. And you had people coming in and speaking, very passionately about trying to protect what Madison is. And they really had a limited voice. And of course, there's been repeated references to Dave Anderson. He no longer lives here. He no longer works here. He's not even a resident of the state. I'm not sure he's a great reference to make. He was part of that very pro-development movement. But I hear things, I hear a lot of stealth terms here that don't sound like what it really is. I hear interim. Interim sounds like it's temporary. Nothing about this text amendment is temporary. It's only as temporary as you want to make it. Because once it passes, it's the law in Madison. It's a regulation. There's nothing interim about it. There's nothing that sunsets it. There's nothing that makes it only valid for 90 days. It's valid forever until you change it. And so there is no such thing as an interim measure unless you actually put a sunset on it. And so that's a stealth term. It tells everybody, oh, don't worry about it. It's just an interim thing. It's just to plug a hole. It's not. This applicant, I mean, Attorney Beatty comes here and says, I'm not really representing a particular property. I'm representing a guy who owns a particular property, who tried to develop it, didn't get what he wanted. I'm coming back now with an application to change the text. And I'm just doing this as an academic exercise that my client might be able to use, but it also, to his own words, he said, it broadens the terms and applicability of the PDD. Why would it is not proper zoning technique or planning technique to utilize a single applicant's or single property owner's application to do a broad scale rewrite of the zoning text. That's more appropriate for a planning session and something of this breadth that applies to agricultural land, that applies to open space and town-owned land that's not restricted, is the kind of thing that should actually have public notice and more public participation at a more townwide level. What you're seeing tonight is just the tip of the iceberg for people who just happen to get word of this and organize at the last minute. Now I represent the Madison Land Conservation Trust this evening, and their concern is for agricultural land, of which there is a diminishing amount, and their concern is for open space. PA 490 land is specifically designed to be protected open space, and to open it up to the potential for a PDD, specifically suggesting that within Section 32 is, I think, dangerous, because what will happen to you is that someone will come up and say, well, you put it in your regs that this can apply to agricultural land, so you must have meant that it should have. Instead of saying someone tries to do it and you say, well, no, we didn't reference that. That's an inappropriate use of a PDD. They're going to say, no, well, why did you put it in Section 32? The reason why it's there is because these three attorneys happen to represent parties who have an interest in Barberry Farm, have an interest in the Winter Club, have an interest in some of the other lands that the small cluster developments might apply to, that 400 feet from the commercial zone, and have interests in other pieces of property that they're interested in developing. And this is not the way to pass a broad-based regulation change, especially where it has the impact to open space and agriculture. That's fundamentally important to the town. And it's also, Euclidean zoning is not a bad word. It has kept Madison the wonderful town that it is. And yes, it's like any zoning tool, it can have deficiencies and benefits, but it's functional and you can continue to work with it. And so this is the point that's being made here by many of the letters and many of the participants, and certainly my client, is that this is a broad planning discussion, which is not appropriate for a single site application. And I wrote a letter. I hope you've reviewed it. It does go point by point and does discuss what I think is potentially wrong or may potentially happen. But the thing is, it's really difficult when you make a text amendment of this breadth to consider what properties might it apply to and what might be possible under it. Because it's so broad, it covers a vast swath of the town potentially. I mean, there are some limiting factors, some dimensional standards that you have, but my initial review is that it applies to a much broader swath of town than certainly the Winter Club. And no one, certainly my client, has absolutely no opposition to the Winter Club being reutilized and redeveloped. It's a seems like an appropriate conversion from a club to a restaurant. But to use that as a foundation upon which to springboard major changes seems highly inappropriate. And I see, Attorney Shansky is still on the screen here. She's not a member of the commission. She apparently isn't representing any client. Yet she's answering questions. She has her screen on. I'm relegated to a faceless voice. Yet, I actually represent the client who has an interest here. And you're having a Q&A essentially with Attorney Shansky as if she's some sort of expert to the commission. She's not hired by the commission, and do not be fooled by that. She doesn't work for you. She doesn't have your interests at heart. She is a paid professional. And if she is making comments solely as an amicus, then she's a commenter from the public, and she should have her screen off, talking facelessly like I am, and not have an elevated status. That's just a procedural thing that kind of bothers me a bit. But there's no right or, by the way, there's no right or wrong answer with a text amendment. You have the unfettered discretion to pass it. You also have the absolute unfettered discretion not to. And you can pass really almost any regulation you want, so long as it meets the uniformity provisions of the statutes. I mean, you really have a broad discretion to pass regs. And so this isn't about saying what you're doing is wrong. It's just that it's so broad and it has so many potentially unintended consequences. And it was done in a meeting privately in a town office with a town staff and private developing interests, and without the public's participation. We're participating now, but we're trying to play catch up. We don't know what happened in those conversations. And I think it's a really bad process. And there's, of course, the applicant's going to tell you that this proposal is consistent with the POCD. First of all, even if it were, it wouldn't mean that you have to pass it. It's not like, oh, if it's consistent, you have to pass it. No, it has to be consistent in order for you to pass it. But given the sheer breadth of these changes, or the potential breadth of applicability of these changes, I can't imagine that the POCD in any way suggested that you pass broad changes like this, and certainly not in the context of a single application. Finally, that Scrog letter that you got that said that this proposition will have no impact on Long Island Sound is nothing but pure fiction. There's no possible way that the Scrog could have considered all of the potential developments and all that are possible under this text amendment and the potential impacts that they might have. Now, they can say that it doesn't impact the other towns, because it probably doesn't materially, but which is one finding they made. But the second finding they made was that it has potentially no impact on Long Island Sound. As a text amendment solely, academically, yes, it's just a text amendment. But the things that can be done under it certainly could have significant impact, because if it increases the intensity of development in Madison, which I believe it would, that certainly would have a downstream impact because we are a coastal town. And so, I think it's fairly broad of them to sort of make that statement. So finally, I'd just like to say that including agriculture and including PA 490, especially PA 490 land, PA 490 land is protected open space. And yes, it can be taken out of PA 490 eventually. But to call it out as a particular potential location for PDDs, I think is inappropriate, because once PA 490 land comes out of PA 490, it's whatever the underlying zone is anyway. So PA 490 has no applicability to PDDs or not. It's just that referencing land that was subject to PA 490 seems highly inappropriate. With that, and I'll leave you to your reading of the letters from both the land trust members and myself, but I urge you to deny this in its entirety and redirect the applicant to go back and come back with something that's directed toward the Winter Club's property and find an appropriate way to redevelop it. Everyone would be happy. And if you want to talk about rewriting your regs, have a greater public conversation about it. And I think you'll find people will be a lot happier. But, this commission was a lot different not that long ago. It might be different fairly soon. You pass these regs, and you have a commission like you had a year and a half ago, 2 years ago, bad things will happen. Thank you.
Thank you, Attorney Ainsworth. Is Aaron still with us? I see we have other hands raised, but I don't have a way to pull them on board with us. In the interim, are there any other questions or comments from the commissioners until Aaron returns? I can add one comment, which is a follow-up to Attorney Ainsworth, and that is that I'm the representative to our regional planning commission, which is the South Central Connecticut Regional Planning Commission. And they did make a comment also about questioning the agriculturally designated land under PA 490 and wondered if that should be removed. So if we do consider a modification of this proposal, that might be one thing to consider under their recommendation as well. I see Maria is here. I'm not sure. Perhaps Aaron has some technical difficulties at Town Hall.
Carol, I'd just like to mention that I think both Ainsworth and Shansky, and I assume all the attorneys have agreed that, and they both have used the same language, but this is going to give us this unfettered discretion to do things that we cannot do now. And it's like, that's harmless. All you're getting is just more power, and certainly you'll be wise in the way you're using it. On the other hand, how many members do we have now? 7? You know that, Carol, better than I. But we could have a quorum of 4 people, and 4 people on the commission then, with their unfettered discretion, which is what Shansky called it and Ainsworth called it, could make a considerable change to the use of land. And I think a couple of members of the public have said, hey, we love you, commission members. You're great. You've done a great job. Sure you will. But I'm not sure we trust you, 4 members with this kind of unfettered discretion. And it's unfettered because it's legislative. And I, for one, don't think we should accept that additional power. It just seems too dangerous to me. There are reasons why things are divided. Congress can declare war, but the president can't. Let's just give the president the power to declare war. There are reasons for why some groups like us don't have unfettered discretion. So it'd be a great power grab if we just made a bunch of regulation amendments and gave ourselves all kinds of power, and then the 4 people who showed up could do it. I just think I really worry about that. And there's no debate about that. Both sides have used the same description.
It looks like Maria Patola is trying to join us. I'm just wondering what's going on here. And this is a new experience for the commission to have.
Maria, can you identify people with their hands up? There's Aaron.
Hi there. I'm having technical problems here and I've had Maria log on as host. I apologize to try to move me over here. We're having some Zoom technical I don't know if it's the town server that keeps pushing me out or Zoom. So I apologize. I will be, I keep getting an error here.
Well, we're having a storm come in too, which may be affecting it.
So my apologies.
And we look forward to 2023 when we go hybrid and in person.
Carol, I believe you've been promoted to a host, so you can see our attendees.
I can see attendees. I'm not sure I can call on them.
You should be able to.
Oh, I can. Okay. Yeah. All right. Great. Thank you.
And I see that Janet has her hand raised currently, but you'll be able to see attendees and call on them as well. And I'll keep doing my best here to.
Great. Okay. I'll do my best to keep things moving forward. Janet, did you want to say something before we go on? Okay. You're muted. Janet, you're muted.
Right. I just knew that we had people in the public who had comments, and we haven't heard from them. And I just wondered if we could get on with that and hear from them before we go any further.
Yes. Great. Thanks. I think we can. So, Dennis Crow, I've just moved you over, I think.
Okay. Thank you, Commission. Thank you very much for having this. I'm Dennis Crow, and I'm from 141 Twilight Drive. I also happen to be on the Zoning Board of Appeals, and I just happened to apply for the Ad Hoc Affordable Housing Committee, which is I bring up because I believe that, to Mr. Ainsworth's point, this very broad approach to changing zoning regulations is, even though it's very broad, it's done in a vacuum, and there are numerous items associated with section 8-30G and the transit-oriented development and all the other requirements that will be coming down the pike. We will have to take a serious look at our zoning from a comprehensive perspective, and I do not believe that having a comprehensive change from one perspective is the right thing to do. To Mr. Ainsworth's point about his letter, he did indicate in his letter that this text amendment would vastly increase potential development of residential, agriculture, and open space lands, and it should be considered as a standalone matter with complete transparency, but not standalone from the perspective of the Winter Club, but not standalone from the perspective of 830G and all the other changes and the affordable housing needs that we have in this community. And he did ask for a broad public input after a visible public outreach effort. A hearing does not constitute either of those. And I think that, you just say, okay, we're going to present it once, everybody talk about it for an hour, and then we vote on it. That does not constitute public outreach. And to make changes of this nature, where you do have, to his point, people with vested interests in items that are other than what the townspeople may have, is not conducive to getting the right result for the people. When we have something that comes to the Zoning Board of Appeals, the applicant must submit letters to all people in the immediate vicinity of the property that he'd like to request a variance for. But we've already discussed the fact that you can't do that in this case because it's so much of the land, and we don't know which land it's going to be, because it might change. At the next P&Z meeting, you might add this piece, and the next one after that, you might add another piece. It's too broad, it's too open-ended, and too risky. And I would like to state my opposition to passing this application. Thank you.
Thank you, Mr. Crow. I'm going to pull in Charlie Schaefer. If you could identify yourself.
Yes. Hi, I'm Charlie Schaefer, 85 Woodsvale Road. And looking at the potential or the proposed text, it's just so vague that it absolutely invites aggressive developers and aggressive attorneys to bring lawsuits against the town based on the fact that they could consider any decision that you as a commission make as being arbitrary. So if you turn something down because the wording is so vague, it's easy to bring a lawsuit. Now, whether or not they win is irrelevant, because well-heeled developers, and I certainly know a few in my business, won't have a problem bleeding a town dry, because they'll know eventually the town will want to save money and just give up. This is such a huge exposure. It's absurd. I think in this present wording, it has to be turned down in my mind, and wait for the comprehensive review down the road. And honestly, something this big really ought to go to a referendum. I mean, the whole town is involved in something like this. It can't be just kind of a one-shot deal. And I really appreciate Commissioner Ron Bodenson's comments that you're just putting too much power in too few people. And it's got to be a bigger table that everybody's sitting at to make decisions like this. So I think as worded, this particular concept is totally faulted. And it's a shame that the Winter Club couldn't get turned into a restaurant with the current wording, because that really does make perfect sense. It's a perfect use for that building. So, you know, if there's not a way to do that, it's unfortunate, but this particular text amendment, frankly, it's just what a legal landslide this would end up being for the town. So I have to say I don't approve of any part of this. Thank you.
Thank you. Next, Matt Bennett. Oh, yeah. Pull him in.
Hi, good evening. This is Matthew Bennett, 917 Boston Post Road. I just wanted to add some comments following from my question and the response earlier. Again, extending my appreciation to the commission for the dialogue. I think this has been really informative and enlightening. And it strikes me, as others have commented, that the decision before you is one of, really broad potential consequence and import. And yet, the way that this has come through the process has been very much relative to, the particular applicant, with the interests of presumably one particular client for which there seems to be pretty broad support. And yet, that applicant and the proposed changes were this approved would have broad impact across the entire town. Add to that, the additional voice that's been brought in by Attorney Shansky, drawing from the breadth of her, significant credentials and experience in the academic settings, and here advising the commission on an amicus basis. And yet, when asked earlier during the hearing, if she could offer kind of a balanced, objective view of both the pros and the cons, was both unable or unprepared or unwilling to articulate the potential risks, of which, as others have commented, there appear to be numerous, if not many. And so, I would urge the commission to deny on the basis of this very narrow, specific applicant, and yet, broad-reaching consequences across the town were this approved. And should there be a desire, on a proactive basis relative to the interests of the town, seek objective, balanced counsel that could, ideally from the part of somebody who doesn't have interests and isn't often before this commission representing clients, inform both the commission and the public objectively relative to the pros and cons, and ideally also help, elucidate a number of the different scenarios or use cases that we should be conscious of as we contemplate the decision before us. Thank you.
Thank you. Aaron, are you back up and running? You're muted, but yeah.
I apologize for that. I don't know what's happening over here at town
No
campus.
worries. I was wondering if we could move forward and call on people who have not had a chance to speak yet.
Yes, absolutely.
Do you want to do the driving at this point?
Sure. And I do have Maria, who has signed in as a co-host as well, just in case something happens. and Carol, you are a co-host as well, so that you can at least man the wheel if something goes down here. And unfortunately, this computer is my laptop. So let's hope not. I have Jerry Birnbaum. If you could identify yourself for the record, Jerry, and unmute.
There we go. Can you hear me?
Yes.
Yes, we can.
Gerald Birnbaum, 9 Bushnell Lane, Madison, Connecticut. I'd just like to say I'd like to hope that you would just take the Winter Club, and that is it. I wouldn't expand on anything else at this present moment. I think things are moving along just too fast. That being said, Aaron, there was a letter from the South Central Regional Planning Commission that Keith Ainsworth mentioned. I had put that right down in my notes. I have lived in Madison for 75 years. I've been a childhood fisherman. I've been a recreational commercial fisherman. I served on the Shellfish Commission as chair for a number of years. And all I can see, okay, is the degradation of our tributaries. And that's not poppycock. For that gentleman to state that the ecosystem will not be affected, it already has been. And I would even consider that we're in violation of the Clean Water Act, which is 50 years old this past year. That being said, I would like to add that you probably wonder why some of us are so passionate about Madison. Well, it seems that the longer you lived here, the more you see that you've lost. And I'd like to convey that. I'm sure that Carol knows that. She's probably one of the longer lived residents here right now. She knows what the town was back in the good old days, I suppose, and knows what, has seen it where it's gone. And a lot of us just want to be protected. I think for a number of people that are watching this tonight, they should go to the letters commenting about the ledges and the General Hart's residents and get a better perspective on why we are so passionate and what we bring to the table. Don't leave us out of the table here. Us old timers have a lot to say. So with that being said, thank you for your presence tonight at this meeting. And please consider not passing anything further on this Winter Club. Thank you.
Thank you.
Joe Mako.
Yes, Joe Mako, 22 Randy Drive. The first go around, I asked a question. Now I'd like to speak in opposition, because this is the proverbial camel getting his nose in the tent. You know what happened in the tent? Disaster. And this is a potential disaster. And I believe, you know, the attorneys that spoke here are opposed to the present system of zoning, the way we've had it for the last 50 years that I've lived in Madison. They want to change everything for some reason. And I don't think just what happened at the General's residence, you upset a lot of townspeople. And I think you're going to do the same if you pass this. And I think Attorney Ainsworth was right. Attorney Beatty should resubmit, and you should reconsider changing the Winter Club to a restaurant. Thank you very much.
Thank you.
I'm just going to go down the line here, Madam Chair. Margaret Nordgren.
Hi, good evening. Jim Nordgren at Margaret Nordgren's Computer for technical reasons. 387 Boston Post Road. I served 9 years on our local planning board before moving to Madison, so I know exactly what you are all wrestling with tonight, and we appreciate your efforts very much. I think we're all in favor of the restaurant conversion, and it's a shame it's been held up with these other riders attached to it. So I hope it can be passed without including any of these expansions. I think making farms and town open space eligible for PDD, that is high density development, is completely against Madison's public interest. We want to be protecting our farms in Madison, not encouraging speeding up their development. Madison was recently recognized by Sustainable Connecticut for our farm-friendly practices, and we want to continue that. And of course, with climate change threatening food production in other areas of the United States, if we really want to be sustainable, we should be doing all we can to grow more food locally. So I'd ask you to please remove these unnecessary and harmful riders to the Winter Club, which we all support. And finally, a comment just on the process. I heard tonight that this is interim, and then there would be a review and rewrite. It seems to me that that's absolutely upside down. Let's review in depth all the implications of making these changes in all the farms and town-owned open space properties in town, and then rewrite it instead of doing the opposite. And as many have said tonight, with the plan of conservation and development being updated now, that seems to me to be a perfect time to make this whole process transparent and inclusive of everybody in Madison. And I think that's really the more proper way to go about examining such a potential broad change. So those are my comments. And again, thank you for all your time and effort.
Thank you. S. Bischoff again? Is that
Yeah,
Jane?
my name's Steve Bischoff. I live on 852 Boston Post Road. I'll keep it brief because I know this is a long night for you all. I am also on the Zoning Board of Appeals, and I have read everything that's been put out here, and I think the language is too broad. I think it is anti-Madison, and I would hope that the board would not pass it as is. And if they do want to consider it, open up to the public in the form of maybe a referendum. Thank you.
Thank you.
Leslie Sood? Leslie, can you hear us? You'll have to unmute, Leslie. There you go. I think you're having technical difficulties. Also, Leslie, it doesn't look like your mic is working. Okay, but I see you with your hand raised lower. You're on twice, Leslie. Stand by. Leslie, does this one work?
How's that?
Okay, that works.
Oh, that works. Okay, sorry about that. Yes, I have you on two different devices because I didn't want to miss a word of this. So thank you so much for all your effort and hosting this hearing tonight. I'm Leslie Sood, 113 Windsor Court, and a member of the Board of Directors of the Madison Land Conservation Trust. And my comment is one is that I agree with all of the statements preceding me in opposition of this proposal. And two, just to elaborate on the benefit of the PA 490 program, which allows families in Madison to hang on to open space, agricultural land, and land that they may intend for eventual conservation across generations, which then eventually allows them to work with the land trust, whose interest, as you all know, is to conserve open space for the scenic and conservation benefit and resources of the community. Without the PA 490 program, or if the zoning is changed that will impact these lands, then it makes these lands very attractive to developers and puts pressure on families to maybe consider the economic benefits of working with developers, and that would essentially, be in competition with our efforts to conserve these lands and make it very difficult for us to be successful. We all appreciate our open spaces in Madison. It's what makes this community unique and beautiful and attractive to new families who want to relocate here and to folks who want to continue to live here. and changing this zoning could have really harmful and detrimental impacts. We do not need to be Old Saybrook or Branford and, look at all these lands as potential sites for big development. Thank you. That's my comment.
Thank you.
Thank you.
David Skelly.
Hi, everyone. My name is David Skelly. I live at 516 Horse Pond Road. I'm a 26-year Madison resident. I'm also a professor of ecology in the Yale School of the Environment and the director of the Yale Peabody Museum. During my time at Yale, I have focused on teaching landscape ecology, conservation, and sustainable development. I am opposed to the regulation changes that have been nominated, in particular the ones focused on town-owned open space and PA 490 lands. I keep this very brief. It's very clear that what is being invited by including these categories of land in the regulation is an invitation to subvert the intentions of those who created those designations. That is not responsible land use planning. That is not the way that Madison has arrived at the landscape composition we have today, which is working really well and has created, as a number of people have said, a wonderful combination of uses that has created a very desirable place to live. And I will say, as an ecologist, a place where wildlife, forests, all kinds of diversity thrive. The changes before you put that at risk. I also want to say, since Attorney Shansky has promoted her connection to the school where I work, that her views represent her views. They do not represent the school. They do not represent Yale. The future of our town and the ability and interest of people to get involved in conserving lands depends on trust. It depends on the trust in your body. It depends in the trust of future residents to follow through on the promises that were made when people gave money, when they gave their time, when they gave their effort to create these designations that are being threatened by the proposal before you. I thank you for your time in considering these important issues, and I urge you again to reject these changes. Thank you.
Thank you. Paula, if you could identify yourself for the record.
Hi, my name is Paula Steer. I live at 48 Deveron Drive in Madison. I am not affiliated with any attorney or developer. I consider myself an average Madison resident, and just trying to put all of this together without having all the technical background. It seems impossible to pass these text changes that are in front of you tonight. I feel that if the majority, given the distraction of holidays and the coming up to Christmas, and I think most people are not aware of this meeting, it should be brought to a referendum. I'm not against having the Winter Club turned into a restaurant, but that should be separate. This just is too big. I believe we need a bigger picture for the future of Madison and that Madison can do better. And I'm just confused why Attorney Shansky's picture is allowed to be with the planning and zoning, because I don't think the average person, if she's not representing the town, could also have that privilege to do this. I think we need to really look at how we're operating in Madison. And I encourage you not to pass this evening. But I do thank you for your time. And I know that this is a lot of work in your hands. And I hope that you listen to the community. Thank you.
Thank you.
Diana Boyce.
Hi, I'm Diana Boyce. I live at 5 Old Toll Road. I'd have to say that I'm opposed to this. I appreciate all of the work that you all do, and I don't want to make this long, but honestly, I'm shocked that the board has the authority to transfer so much power from the present way of operating to itself. And I think it would be a shameful thing for the board to do that. I also think I'm disturbed by Attorney Shansky's presence and highlighted presence at this meeting. And I think it raises concerns about how work gets done. And I'm sure that you all want to do the right thing, try really hard to do the right thing, but to pass this now with all of the concerns and without having properly deliberated the negative consequences, and in this hearing, only talking about the positive consequences, would be a very big shame. So I hope you don't pass it.
Thank you. Ben Diebold? Ben, I apologize. Do you go by Diebold or Diebold?
It's Diebold.
Okay, thank you, sorry.
Yeah. Yeah, I'm Ben Diebold. Live on 19 Woodsville Road, and I'm also president of the Madison Land Conservation Trust. And thank you for the opportunity to speak, and thank you for all your work tonight at 9:13 on a dark and cold Thursday night here. 10 days before Christmas, while we consider a massive revision to the regulations regarding Madison's open space regulations, which I think is a really kind of problematic issue. I think it's a problem that we're in the situation that we're in tonight. It's a problem that we're sitting here discussing potentially gigantic revisions to open space regulations on a Thursday night at a Planning and Zoning Commission meeting. It's with all due respect, it's just not how it should be. This is a conversation that should be taking place at a different time, at a different place. It should be part of a planning and at a plan of conservation and development. It should be wider public input. It shouldn't be an adjunct to a winter club application to be turned into a restaurant. So there's something that's gone wrong with this process, and we're kind of concerned and honestly a little bit depressed about it. And I'll say something about the land trust involvement here. We rarely appear in front of planning and zoning. In fact, in my years of involvement with the trust, about 15 years now, we've been in front of planning and zoning contesting a development project, I think maybe one time. We are not reflexively anti-development. We see ourselves as mainly focused on our work of stewardship and conservation. The only time we've been in front of planning and zoning is when there was a marina development project where the developer wanted to put 8,000 cubic yards of gravel into a tidal salt marsh. In that case, I believe he was represented by Attorney Shansky. And that's the only time we've been in front of planning and zoning. But this case has certainly gotten our attention because we feel that this is a gigantic revision, potentially, of open space regulations in Madison. Attorney Shansky thought it was inappropriate to look at the GIS systems and to think about the scope of the acreage involved in this. And I can see why she would be uncomfortable doing that, because when you go through that exercise, what you'll find is that it's gigantic. We did that. We, as best we could, fed it into our GIS system with the time we had available to us, at lunchtime yesterday or whatever. And what we found is that when we fed these 6 parameters, as best we understood them, into our GIS system, and we've made this available as exhibits to the commission, it affects hundreds of properties and thousands of acres distributed all the way across Madison. It is a gigantic revision. So even though technically it's true, nothing actually happens until a specific property is brought to the direct attention of the commission, it does in fact create a gigantic pool of eligible properties that could be identified by developers like the three developers who composed this, the committee that composed this addendum here, create this gigantic pool of properties that could be used to create new projects. So that's available, and I encourage people to look at it. And I'm sure that there'll be ways to criticize the map that we put together, and I'm sure there'll be all kinds of problems with that, which underscores another kind of problem, which is that if there are problems with that presentation, then that's a problem with the feedback process. There's incomplete information. We didn't have enough information. That's all part of the education process that could have been developed in the last months about what this proposal means and just how broad it is. Part of that has to do with this PA 490 project, which does seem like a technical thing, and it's often referred to as farmland. And it's true that it does impact farmland in Madison, but actually the broadest use of the PA 490 program in Madison is forest. And you'll see that when you look at the maps in North Madison, where it's broadly used for forest lands. So anyway, I thank the commission for its time. I don't want to go on too long. I encourage you to vote reject this proposal completely, and it needs to be taken back for a much more serious, longer term discussion in a much more measured way. And thank you very much.
Thank you. We have Liz. You can identify yourself for the record, please.
Can you hear me?
Yes.
Okay, my name's Liz Villadaki. I live at 21 Tamarack Drive in Madison. I've lived here for 22 years, and my parents lived here for 20 years before that. I agree that this should be opposed. I think it should be brought to a referendum. I think it's absurd, as Mr. Bodenson said, that this has so much, potential for abuse of power. And I thank Attorney Ainsworth for clarifying all the salient issues. I think the Winter Club being turned into a restaurant is fine, but I think, the way that is going about being twisted around is not healthy for our town. And again, like passing this, I think would just be absurd. So thank you. Oh, I have one last question. What is the next step? Are you all voting on this tonight in front of us? Or how do we find out how the vote goes?
Once we close the questioning and the comments from the public, we move to go to deliberation. And then it becomes a discussion among the commissioners what our next step will be. Erin, do you want to elaborate?
Yes, so this is an opportunity. We're currently in the opportunity for public comment. And then the commission may ask questions of which that requires additional information from the applicant. You may request an extension to continue the public hearing and to leave that open prior to closing. If the public hearing closes, you cannot receive any new information or receive any other public comment. So that's something for the commission that you need to consider ahead of closing.
Well, otherwise we might vote tonight or we might vote next month. We don't know until we deliberate that. I think she was asking when might we vote, but when we do, it'll be in an open meeting that everybody can attend by Zoom at least.
That's correct. Barry Schlosser. Barry, can you unmute?
There we go. How's that?
Yes, we can hear you.
Thank you. Barry Schlosser, 21 Sheffield Lane. So I've heard a number of people talk about a referendum. I would support that too. I hope that's the direction we go. As a practical matter, how would that come about? That's a question I have. Can you answer that now?
Yes, amendments to the zoning regulations fall within the jurisdiction of the Planning and Zoning Commission. And that process requires a public hearing process in which we are going through now. It is not a regulatory action taken by the Board of Selectmen or via referendum.
So all of the people who have asked for a referendum, it took me asking a question to get someone to say that that's not an option.
This is an opportunity. We're allowing everyone to make their comments, and then I'm, taking notes here and providing information to the commission. I didn't want to interrupt everyone's comments with additional staff comments or comments from the attorneys here representing the applicant. I wanted to make sure that everyone who has sat here for almost 2.5 hours to be able to.
Is there a process or a procedure where this can be brought forward to a referendum? Is there any legal reason that couldn't happen?
Yes, statutorily, the zoning regulations and the process for amending the zoning regulations is prescribed in the statute, Section 8, and it falls within the jurisdiction of the Planning and Zoning Commission. It does not include a referendum process. Public hearing process that we're in now currently. This is the process.
All right, well, I just learned about this today, so I don't really. I mean, I've heard everybody speak during the meeting. I'm formulating an opinion about it. It sounds to me like it's a big step forward for the town to take. And I'm hoping that this process doesn't end tonight as a vote, but that it continues and more public input is sought, because I don't know that a large percentage of the town is aware of this. I mean, I appreciate everyone's effort to speak up tonight about it, but I feel like this is a potentially a very major decision that it would impact the town for many years to come. And I'm hoping that we don't, find out in the next hour how this goes, or that it's approved without more input from the town. Thank you.
Thank you.
Wendy Sean?
I just want, Wendy Schoen, 194 Bartlett Drive. I just want to go on record as urging you all to vote against the proposed wording changes, and for all the reasons that other people have said. I don't really need to say anything more because it would just be repeating what other people said, but I just want you to know where I stand. Thank you.
Thank you. Laura Downs?
Hi, I'm Laura Downs. I live at 54 Quarry Ledge. I think that you should reject this proposal and concentrate on your work for the POCD, which will hopefully include public input. I think that's where the public can have their say and talk about the areas that they see opportunity in, and also see which particular properties should be developed, whether that be for affordable housing or restaurants. If Mr. Lulaj actually wants to open a restaurant on the site of the Winter Club, I think he should. I think there are many people in Madison that are interested and excited about that. And he should open a restaurant there. He could apply for a special exception, I believe, without the overreaching text amendment. And that, I think he would have a lot of support for that. So I don't understand why Mr. Beatty wants to try to go ahead with this this far-reaching text amendment if he really was representing his client. So thank you.
Thank you. Ann Tarpey Flanders?
Yeah, hi, thank you so much. I've learned a lot tonight, and I just want to go on record that I'm really opposed to this whole process and changes to the text. Thank you.
Thank you. Fillmore McPherson?
Yes, thank you. I finally got it off mute. Thank you for all the discussion tonight. I just want to be on the record of supporting all the people who have spoken against this overreaching potential regulation. And let's have a new restaurant down where the Winter Club was, but we don't need to go anywhere near this far in this new regulation. So I second what all these other people have said. Thank you.
Thank you. Fran Brady.
Hi, thanks. Fran Brady, 108 Genesee up in North Madison. I'm also the founder of Mad for Trees. I wanted to support the comments made and go on record that I oppose the amendment as proposed. I'm concerned also with what Ron said about the power of a 4-person quorum making such a significant change that could impact the whole town with bylaws or regulations that call for no referendum. You've just heard, and I'm sure, I don't know how many hands are raised after me, but my guess is you've heard from more Madison residents than the town hears at a budget meeting, a budget referendum, or a budget vote, you know, where the quorum is 75 people. That's how concerned people are about this, that they're here to express their concern. So thank you very much.
Thank you. Kristen Morris.
Hi. I just want to go on record that I'm absolutely opposed to this. I think this opens the door for potentially disastrous results.
Excuse me, Kristen, we can't hear you. And if you could just identify yourself for the record.
She seems muted.
She just muted, but she's very faint. If you could unmute and speak louder.
Kristen Morris at 30 Canborn Way.
Thank you.
Oh, sorry.
Now
I just wanted to go on record that I'm absolutely opposed to these changes. I think they could be potentially horrible for the town of Madison. Thank you.
Thank you. Maureen D.
Hi, good evening. Thank you. Just for a quick comment, just to voice my opinion against this proposal as well. I appreciate all the comments before me. They were very enlightening and really brought to light a lot of things that I would never have even thought about being a layperson and not a zoning attorney. I've sat through many, many, many evenings of P&Z meetings for proposed PD&Ds in my area of River. I'm at 73 River Road in Madison, and I will have to report the bar is pretty low for the approval of these. Almost, they've all been approved in my area, even with a lot of opposition by neighbors, providing expert witnesses and on and on and on meetings. So to have the change, these proposed changes in whatever the regulations, the laws, whatever, would really be very impactful. So I just wanted to voice my opinion against this. Thank you.
Maureen, could you just identify yourself and your address for the record?
Yeah, I'm Maureen Druin. I'm at 73 River Road in Madison. Thanks.
Thank you. Is there anyone else who would like to be heard? Ian Taylor?
Yes, hi, my name is Ian Taylor. I'm at 149 Country Way. I've been a Madison resident for 26 years. I'm also the vice president of the Madison Land Conservation Trust. I have to say, unlike the last caller, it's actually a great segue. I've never attended a commission meeting before in my 26 years. So I guess I'm a little embarrassed by that. But I have to say, if the process by which this proposal came about is the way it was described is the normal course of business. I'm actually quite shocked about that. Really with really very little input from really anybody besides development lawyers. And the concept that this was done to ease the job of the commission in the future is actually laughable to me, and that's not hyperbole because I actually laughed at that. So I just like to also be on the record as being totally against this, and I really hope that it does not go forward. Thank you.
Thank you. Chris McKeon?
Hi, my name is Chris McKeon. I am an attorney with an office address of 900 Chapel Street in New Haven. I am also a resident of the town, have been a resident for 27 years, raised a family here. And while it is true that I am typically before this commission representing developers or owners wanting to do something with their property, I also am a resident and am looking at this, I guess, entirely different than the others that we've heard from tonight. I am familiar with the PDD process, the PDD regulations, not only in Madison, but in many other towns. And I guess I disagree with the voices that we've heard in the sense that the PDD for a Planning and Zoning Commission is a very useful tool. And it's a useful tool in the sense of dealing with change and change that is happening and will come. And vesting your commission with the ability to be a gatekeeper under a PDD regulation not only gives you the power to control the types of change that people who own land want, and also to direct the type of development that we would all prefer rather than some other uses. What I really want to encourage the commission to do is to consider having more public input. Obviously, I hear my fellow neighbors wanting, and quite frankly, they're incredulous that they didn't or weren't aware of this, and they should be, and their input is important. So I would encourage the commission to leave open the public hearing, allow the applicant and others to continue to weigh in and perhaps narrow the language that Aaron and Attorney Beatty and Attorney Shansky and myself lent our assistance to try to craft in a way that would narrow the language and would target the specific properties that the Planning and Zoning Commission identified as being properties that will face change and a desire for different use. And I think that there's a misunderstanding of the reference to PA 490, which as I understand it, is a tool that a property owner can use to pay less taxes, in short. And the PA 490, any given property owner can take their property out of it. So I don't know that having the ability for a property owner to seek the benefit of a properly designed and approved PDD encourages people to do that or not. But it is not something that is permanent, a PA 490 designation, as I understand it. But that's just an example of what I think is a lot of misunderstanding about what this is And I would encourage more debate and consideration by the commission, so that the concern that this is an overreaching and devastating change for the town can be at least attempted to be addressed. And maybe it can't be, but I do think that the opportunity is here. We've started the debate. Why not continue the debate and go back to the drawing board with some narrowing of these areas to which, again, the Planning Zoning Commission had previously indicated were areas that are going to, and maybe even presently are, facing change or a desire for change of use. Lastly, I did want to, I was involved in helping to try to draft this language. I was not paid. I was not working for a client when I did so. And I do not have any clients who presently are seeking a PDD designation, nor, to my knowledge, are even contemplating one. But I am in favor of the PDD, which is, again, a very useful tool, being able to be applied to a broader group of properties than the original regulation applied to. Thank you for your attention, and thank you for your hard work. I personally trust the Planning and Zoning Commission, and if you vote to give yourself the ability to determine whether or not a PDD map designation in the future is applicable or should be applicable to any given property, I would trust that you do the right thing, and I would trust your decision regardless of what it was. So thank you. I appreciate your time.
Thank you.
Thank you. There are no more hands raised at this time, Madam Chair.
Okay, thank you. How's everyone holding up? Do we need to take a break, or we ready? I think I'd appreciate some comments and feedback before we may even make a decision of whether we should close the public hearing. Yeah, I see a hand raised from Attorney Beatty. Would you like to make a comment?
Yes, if I could.
Go ahead.
Thank you. Jeffrey Beatty, 705 Boston Post Road, Guilford, Connecticut. I would request that the public hearing be left open so that we could amend the amendment based on the feedback that we've heard tonight, the comments from Mr. McKeon. I don't think it's certainly not lost on me and my client, that there are a fair number of people who've advocated support for at least the use of the property for the Winter Club property, which is my client's interest. And so I think the opportunity to revise the language in a way that may be more palatable to the community, to the members of this commission, and ultimately to my client would be appreciated. So if the commission would consider continuing the public hearing to allow us that opportunity, I'd appreciate that.
Thank you. I think also in the spirit of transparency, it would be great to continue the hearing. How does everyone feel about agreeing with Attorney Beatty that we can continue the hearing?
I would be in favor of continuing the public hearing to the, I don't know if it's the next meeting or the second meeting in
Mid-January.
January.
Yeah. Thanks. Other thoughts, Ron?
Well, I think it just continues the problem that we have, which is to consider such a major change, whether it's amended a little bit or not, in a planning and zoning hearing in the middle of January and have another hearing. this really should be part of our 2023 plan. It's a major, major change. It's inexplicable to me why it was brought to us like this at the same time that the Planning Commission is doing the 2023 plan. That has a broad base of input, lots of commentary, lots of hearings, lots of consideration. So to continue this public hearing so that the proponents can come in with a couple of amendments that eliminates one or two of the items they wanted to have us be able to act on. Again, puts us right back where we are tonight. The population of Madison is saying they're against this. If you're going to consider it in a larger form. And we're just punting it to January for another 2 hours at night when there's not enough information. I'm for closing the public hearing and voting tonight. I don't, the public has spoken, the applicant, let them come back in February with a new proposal that we can consider. It would also be good if the planning director would put this on the table as part of what we're talking about in 2023 to change regulations and plans and purposes. That's where it belongs.
Okay, Janet?
Am I unmuted? Whoops.
Yes, you're fine.
Oh, no, you just muted yourself.
I already took myself off. I like what Attorney Beatty said. I think that I would feel more comfortable as a new member of the commission, especially to see this in a narrower scope. And I know that you originally said you did this to make it easier for commission members, that lumping everything together. I personally think that each of these things should be considered separately because they are so very unique. And I know Erin went through, and I had not seen that memo before from the other meeting until tonight, and she just went through the properties really quickly, and I was trying to keep up with it. They're vastly different and really cover a broad area of Madison and North Madison. So I think that they need to be considered separately. It would make me feel much better to consider these properties separately, at least at this point. And as Ron said, we need to go forward and, work on our plan. That's so important. But now I think to consider your client's property, Attorney Beatty, I would feel much more comfortable about that. And I really appreciate so many comments from the public tonight. That was very helpful.
Thank you. Bob?
Yeah, just, it seems to me that if there is a consensus on the commission that this proposal is so broad and the timing now, it really is inappropriate to discuss it, that we really need to begin work on the POCD revisions. It would seem to me that to hold over a vote on this until a couple of weeks from now is just a bad idea, because it's giving the public a view that, well, the commission is kind of mixed on it. They want more input from the public. I don't know what more input we can get that would inform what I'm hearing so far and what I guess from the commission, but I may be wrong that, yeah, let's find a way to approve the restaurant, but that the broader PDD designations for a large swath of our town is inappropriate at this time. Let's do the POCD first. So we should vote down or vote on the proposal as it is now and encourage Attorney Beatty to come back with something that would be the restaurant only.
Thanks. John, any thoughts?
I would agree with Robert if that's possible. I don't think, well, I don't need to hear more input.
You're right. People rarely agree with me.
I don't think that's what he meant.
The input is overwhelming. The positives are relatively few and the negatives seem significant. So I don't think that continuing it to 2 more weeks is really going to change that. It seems like Attorney Beatty probably ought to come back with a new proposal that better serves his client's interests.
That may be what I'm able to do within the next 2 weeks without having to start the whole process all over again.
Michael, any thoughts?
I think I'm agreeing with Ron. I think we should close this out and allow them to reapply.
And Shawna?
Yeah, I imagine that in 2 weeks, there would be yet another prolonged meeting with lots of discussion that may be fairly repetitive. So I agree. I think just closing this out tonight and then really revamping what they bring back makes more sense to me.
And by revamping means that not entertaining the PDD change of language or additions. I mean, I think, the offer has been made to keep it open for a while and allow a chance to modify what's been presented to us tonight.
I think there's been enough expressed concern about the process of how this came about that I think that people are interested, I think, in a little more transparency about how these amendments come to be and maybe more input in upfront about how that happens.
Mm-hmm.
I think there just seems to be some distaste about this whole process, which I'm not necessarily in agreement with, but I think that we need to pay attention to that.
Yeah. I mean, we don't have much control about the process really, but I think also the question that's been raised by us and by the public about how does it dovetail with our plans, the plan of conservation and development and the stage, what stage are we in of doing the revisions, and in a way, what comes first, the horse or cart in this case, should we be thinking of it as something that we recommend in our POCD before we go ahead and make these kinds of changes to our zoning regulations? I don't know, Elliot, do you have thoughts about that now that we've kind of circled around?
I mean, my personal opinion is I would allow them to come back and modify with the application that they have in place rather than make them start all over again from scratch. But obviously I'm seem to be in a minority in that thought. But the attorney asked for the opportunity to make revisions to his application and come back in front of us again. And, I would respect that. And I would like to see that, but if everybody else would rather vote on it this evening, it's obviously majority vote here.
Well, I'd like to add that maybe I'm a glutton for punishment, but we heard a lot of voices tonight also express that they've just heard about this, and had, since yesterday to prepare. So in a way, I see the benefit of keeping the meeting open and allowing the public to express more of their views. Maybe they'll be repetitive, but maybe not. And, again, if it's a modified proposal, I don't know if that would change people's minds in the public. I think, the biggest contention seems to be the PA 490 and maybe perhaps second by the town-owned property. But Aaron, I also agree that just seeing those meetings from the 2020 meeting for the first time tonight, none of us really have a whole grasp on what properties might be considered or might not be considered. At the same time, none of us can predict what another commission 10 years or 20 years from now might do with these modifications.
Yeah. So I see the benefits of as several, and just taking notes from comments from the public, and some wanting to see visually what properties this proposal applies to, perhaps narrowing the scope, as Janet has said as well, perhaps having an opportunity to read through what some of these opportunity areas are, see where they are, perhaps get some more information from the applicant, and even staff, as far as how, if there is a desire or a current interest by some of these properties on the list, to allow this opportunity for redevelopment. For example, the Winter Club. The current regulations in a residential zone do not allow a restaurant use in that property. And so looking at your previous actions and the denial of that text amendment to allow restaurants by special exception, and seeing this overlay as a possibility, it is something for the commission to look at, and perhaps to narrow the scope of this amendment. Currently, the regulation applies to 2 properties, so you took it slow from the beginning. In where this particular this overlay could apply, and moving in that direction, you could look at just this potential language that could incorporate that the Winter Club property into the criteria, or perhaps looking at other of these opportunity districts to look at the language as to why the text was included. I can speak for the town, I think, comfortably that there are 2 separate items, the designation of PA 490, 2 separate line items, separated by the or, that town-owned property, there's no desire or initiative by the town to convert town open space to redevelopment. And I know I heard that a few times, of the implications of converting town-owned open space. That is not a desire that has been vocalized by anyone in the town that I have been in contact with. The town owns facilities and other property that is not considered open space, which is why town-owned property is a separate item. So I did want to clarify that for the commission and for the public, and as well as the property. As far as going through the plan of conservation and development and looking at broader planning initiatives, that's absolutely part of the process that we're initiating here for the 2023 year. That's a very public process. There are a lot of stakeholders in the community. The commission will be engaging with the assistance of our planning consultant. We will be engaging with all of these stakeholders, community members, and inviting you to participate in this broader plan. And just for your reference, while you're here, the commission has dedicated their first meeting of the month, which is the first Thursday meeting, to discuss solely the plan of conservation and development. There hasn't been a lot of meat and potatoes discussion, I should say, as far as real matters. At this point, it's very much just reviewing the existing document. There hasn't been any real substantive work accomplished at this time, but we look to invite everyone beginning in the new year to take part in that. I do believe in that level of transparency. And as far as discussing potential opportunities or mechanisms for redevelopment of properties, that is part of my role as the town planner in meeting with property owners, developers, attorneys, people for land acquisition for conservation matters across the board. And so voicing out options and looking at potential language for text and trying to tie in some of the efforts that the commission initiated earlier in 2020, it, in my opinion, doesn't constitute closed doors, non-transparency. This was assistance to an applicant looking to make an application, and as we've discussed, anyone can make a request to the Planning and Zoning Commission that to amend the regulations or the map. This power in the statute is given to you. You have this great authority, and you need to use discretion in making your decisions. This is not a decision that can be passed to another agency within the town. This falls within your role. And so that's my 2 cents. As it was introduced to you earlier in the evening, this does not have to be a fixed document that you're looking at this point. This request that's been made by the applicant, this is not a commission-initiated amendment, which our next public hearing this evening will be. So there is yet another public hearing this evening for a commission text amendment. This particular amendment can be amended during the hearing process. So I do want to spell that out to you, that and if the commission has specific concerns or information that you're looking for, or simply wants time to read those things, this is the feedback that you give at this point in the meeting to guide the applicant or staff as far as what you're looking for, what would help you make your decision.
Madam Chairman,
Yes, Ron.
I'm ready to make a motion to close the public hearing based upon what the majority of the commissioners have indicated tonight. So I make that motion this time.
Is there a second?
I'll second it.
So it's seconded by Michael. Any further discussion? All right, I think we'll move to a vote then. All in favor of ending the public hearing?
Aye.
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 All opposed? It's 2 of us. All right, so we close the public hearing, and could I have a motion then for a vote?
Going to be any deliberation, Madam Chair?
Sorry, sorry. It's been a long night. You're right. We need to move to deliberation.
Do we need to make a motion to deliberate, or can we just deliberate?
You don't have to you do not have to take action this evening.
I know.
As well. You have 65 days to act following the close of a public hearing.
Thank you. So at this point, we've just voted to close the public hearing.
Okay, so what about Attorney Shasky? Nothing personal, but you seem to be still here, and you're here as part of the public, right?
There's no further communication with the applicant when the public hearing is closed, Bob.
Okay, so
she's not the applicant. I thought you said she wasn't the applicant.
They
she's
can
not
also
the applicant.
All right, I'm just saying.
So at this point,
So the applicant's still here, and there's a member of the public here with the applicant.
are you asking? You're asking.
Okay, I guess I'm asking, what does closed mean?
So the
Does it mean
public
that
hearing closing means that you are not able to get any more additional information from the applicant, nor comments from the public. So the public hearing portion is closed. So now, based on the information that has been submitted into the record during the hearing, the commission is responsible for making a decision. If you are would like to provide staff with some feedback as to the directions in which you're going or the reasons, I'm happy to draft a resolution based on that feedback to bring back to you for your next meeting to take action so that that language is crafted for you
Yeah, I just have a quick question. So it's closed for public input, but the public is still listening.
Absolutely.
Okay,
This is
great.
still a public meeting. Absolutely.
That
All
is
of your
clear.
meetings are
Okay,
public.
fine.
Yeah.
I understand. Great. So I take back my comments about Ms. Shansky and Mr. Beatty.
Okay.
So what are everyone's thoughts? Should we continue this at our, continue the deliberation or continue till the next meeting, or should we go ahead and move to a vote?
I would move to a vote because I think we should not mislead the public into thinking that we are going to go ahead and approve anything close to what has been proposed. It's not like we like the idea of taking a large swath of Madison and putting it into a PDT. I think instead our consensus, I may well be entirely wrong, is that we need to work on the POCD first and not continue this separate PDD process immediately, although we would love to find a way to approve the restaurant, and that we should let the public know that by voting this proposal down at this time, which I would move.
Is that a motion then?
Yes.
Is there a second?
I second.
Any further discussion?
And Aaron, you correct us. Can we vote this down, or do you want us to give you paragraphs of reasons? I think it's based upon what we've heard tonight. I think it's simply an overbroad change to our regulations that's inappropriate at this time during our deliberation this year of a new plan of conservation. But if you think it needs more detail, I think that's probably sufficient.
You've seconded Bob O'Connor's motion.
Right.
And
Right.
now it's discussion amongst the commission. Yes, I believe the commission should always put their reasons for their findings on the record, and that should be based upon what is in the testimony during the public hearing and discussions during the public hearing.
Well, I gave 2 reasons. I'm sure there's more.
Do you want to repeat what those are, Ron? It's been.
Yeah, it's an overly broad change through our regulations by including land for us to consider that's inappropriate to be considered, whether it's farmland, municipal land, or whatever. And it's not an appropriate time to consider such a broad change of our regulations during the year we're actually
You just cut out of my
considering and that these kinds of proposals or considerations are best considered there. So that's and as I said, the owner can apply for something more specific for his own property. This is way too broad and unnecessary just to solve the restaurant problem.
Aaron, did you get that?
Thank you.
And is there further discussion? I think that was pretty clear.
The other concern or objection is the empowerment of the commission to have more discretion on these items. Not that it applies to the current group, but it's easy to imagine a scenario in the future where the group is completely different and it's been empowered by somebody else, it just strikes me as the wrong way to go. I would agree with Ron regarding the overbroad nature of the amendment. I mean, I was not here obviously in the summer or in 2020, but just doing some background reading and seeing the reporting on it, it does seem like this is a very broad solution to a more specific problem.
Thank you, John. Are we ready for a vote? So all in favor of this motion? Opposed? Abstain? I think it carries.
Thank you very much.
Thank you. So moving on to our second public hearing, if it's 10:08, I think we can do this.
We need to.
So could I have a motion to
Okay,
open
Aaron.
open the public hearing for 21-19 regulation amendment, temporary moratorium extension. We are the applicant, the Madison Planning and Zoning Commission, Article 2.20.4, extend our temporary moratorium on recreational cannabis establishments until July 1st, 2023.
I can quickly go through this.
That'd be great.
For you all. Just about a year ago, the Planning and Zoning Commission adopted a temporary moratorium on the actually, I should back this up here. On recreational cannabis establishments. That was a direct result after the passage of Public Act 21-1, which legalized the cultivation, sale, transport, and distribution of adult use cannabis. So in creating this moratorium, this was a 300-page bill for the legalization of recreational marijuana. The town looked at this as a whole and wanted to kind of get a grasp of all aspects having to do with recreational marijuana, the actual uses versus laws, things of that nature. The Board of Selectmen created an ad hoc marijuana legalization committee that was charged with preparing recommendations for the conditions of use and sale of cannabis within the town. This committee has been working. They were working and meeting quite actively earlier in the year and have had some delays in meeting again. And so the initial expiration of the moratorium was, I believe it was last June. We've already had one extension due to the time frame. Basically, the committee is looking to get back together once again and finalize. They've made some strides. They want to finalize their recommendations to the Board of Selectmen, which in turn may make recommendations to the Planning and Zoning Commission as far as establishing regulations regarding the use and sales. So they're asking for just additional time. If the moratorium is not extended, then the uses would be considered legal uses in the town, and that's something that we're looking to prevent until we have a handle on the overall regulations and can formulate appropriate decisions. So this is fairly simple. It's another 6 months to July 1st, 2023, and this should be the last extension of this temporary moratorium. I'm here to answer any questions for the commission, and then we can open it up to public comment as well.
Did we officially move to open the public hearing, Erin?
Oh, I thought you did when you.
I tried, but I'm not sure we got a second or a vote on it. Did we? maybe we could just go through the process quickly again to officially open and I so move. Could I have a second?
I'll second.
Thank you, Michael, that was, and all in favor.
Aye.
Thank you.
Aye.
Great. Yeah, I think
Recap again, now that we're officially in the meeting. There is in the application documents, which I hope the commission was able to read within the attached to the agenda, I should say. This is a temporary moratorium extension, a second extension for this moratorium on recreational cannabis establishments until June 1st, 2023, to allow the ad hoc marijuana legalization committee to finalize their recommendations to both the Board of Selectmen and then, if needed, to the Planning and Zoning Commission as well for future regulations. Our summary kind of goes through our history here of that, as well as our proposed language. It is Article 2.20.4. And the new extension, so it would be our current expiration date is December 31st, 2022. And the new expiration date would be July 1st, 2023. This regulation change was posted in town clerk's office in accordance with the statutes. It was also referred to our neighboring communities, Clinton, Killingworth, and Guilford. Was also referred to our Regional Planning Commission, which is through our South Central Council of Governments, Regional Council of Governments, in which there was no comment returned, no impacts. So I'm able to answer any of your questions if you have them, or open this up to public comment.
any questions or comments from commissioners?
Pretty straightforward.
And I don't see any hands raised from attendees. Any questions or comments from the public? I think this is fairly straightforward, and
I did have one question or comment. The prior motion that we passed, the reason given for a moratorium was that there was going to be investigation, analysis, thinking this through, where should Madison come down on it? And
Yes.
It made it sound like the Planning and Zoning Commission was supposed to do that, but apparently it's the ad hoc committee. Is someone really doing this? I mean, someone is having hearings and taking community comment, or we just extending it and not much else is going to happen? I don't know.
As I mentioned, the Board of Selectmen established the committee. The committee had
Right.
been meeting. The committee consists of representatives from various commissions, including your commission. Giselle
Okay,
Egan
right.
is the representative of the Planning and Zoning Commission. There's Youth and Family Services. There's
But they're meeting and having hearings and getting input, or has nothing
no,
happened?
has not been. There has been a hiatus in meeting, which is the reason for the moratorium.
Okay.
The committee will meet again in the new year to finalize.
Okay.
They are public meetings. They've had one public information session, which was earlier in the year. It was not well attended. I serve as staff for the committee as well. And so that is another reason. I think we haven't had a lot of public, at least I haven't. I've had hit or miss conversations. I haven't seen a lot of interest at this point. But I think it is important for the committee to have another public forum. There was a general Zoom meeting with a survey via Zoom during that meeting. But again, it was not well attended. So that's one of the concerns.
thank you, Erin.
Madam Chair, there is one member of the public who would like to speak on this. Joe
Okay.
Mako.
My question is, what is the role of the P&Z Commission in this process? I mean, if somebody wants to open up a retail store that's already retail and sell marijuana, what role will the Planning and Zoning Commission have? I don't understand what your role is going to be. Do you have an idea?
So the concern or the question is whether or not there will be a prohibition. I think the Board of Selectmen wanted to look at this on a broader level. Regulations for prohibition could come from an ordinance level or through which is through the Board of Selectmen, or through a land use regulatory mechanism through the Planning and Zoning Commission. That decision has not yet been determined or whether or not there will be a prohibition. If the use is permitted, then zoning regulations, the way that the statute was written, would assume like a special exception review process through the Planning and Zoning Commission. So regulations would need to be drafted as to the review process or any standards or locational, separation distances, things of that nature. So that would then fall under the jurisdiction of the Planning and Zoning Commission.
So that means basically if it's approved, you have to rewrite some regulations.
Yes, there would have to be a text amendment to address.
And would that process be open to the public?
Absolutely.
Okay.
Any other questions or comments? In that case, could I have a motion that we close the public hearing and move to deliberation?
I move to close the public hearing.
And move
I'll
to
second that.
Second. Great. Okay. Any further discussion or deliberation on this topic? If not, then could I have a motion for a vote
I'll move that we vote.
to?
I'll second it.
Yeah, the vote is to delay a decision until July 1st.
Thank you. So we have a motion to for a temporary moratorium extension on the recreational cannabis establishments until July 1st, 2023. Could I have a second?
I'll be the second.
Thank you. Any further discussion? If not, we can take a vote. All in favor?
Aye.
It's unanimous.
All right. Great stand.
All right.
Just for the record, Madam Chair, Elliot Hitchcock has left the meeting.
Oh, right. Thank you.
Prior to the opening of this public.
Okay, thank you. Okay.
And I'm about to lose power, but
Yeah, it's raining really hard. I don't know if the wind is hit yet, but moving on to the regular meeting, we have 2 receipts. Aaron, I don't know if you want to comment on them. One
We
is,
schedule a couple public hearings. One is a special exception for an existing industrial building of welding works. In addition to the rear, it's a special exception use, requires a public hearing. And so we would need a motion to schedule that public hearing for the January 19th, 2023 meeting. And the second is 155 New Road, which is a petition for zone boundary change per section 32 of the Plan Development District. This is that northern property that is currently identified in your PDD regulations, which also requires a public hearing. However, the request for scheduling that public hearing is to the February 16th, 2023. We would need a motion for both of those dates.
okay, so could I have a motion for 22-32, which is 32 New Road, to schedule the public hearing for January 19th, 2023 meeting? Could I have a motion?
I'll move.
Sean, thank you. And a second?
I'll second.
John, any further discussion? All in favor?
Aye.
Aye.
Great, thank you. And could I have a motion for 22-31, 155 New Road, to schedule a public hearing for February 16th, 2023 meeting?
I so move.
Thank you. And a
I'll
second?
second it.
Thank you. Any further discussion? All in favor?
Aye.
Aye.
We'll do that in February. Great, thank you. Pending applications, Erin, did you want to talk about them?
Yes, these were received prior to our last POCD meeting, and also need to be scheduled for a public hearing. Actually, one is the Town of Madison Salt Meadow Park Dog Park. An extension has been granted by the applicant, and public hearing request to table to the January 19th, 23 meeting. And the second is also a Town of Madison application, which is 300 Green Hill Road, which is Polson School. And these are the removal and replacement of the 4 tennis courts with 6 new tennis courts. And that is also to schedule a public hearing for January 19th, 2023.
Do we need to make a motion for that, Erin, or is it?
Yes,
or-
for both of those, please.
For both of those. Okay, so the first one is 22-25, 1362 Boston Post Road. A motion for public hearing to be tabled to January 19th, 2023. Could I have a motion for that public hearing?
Sure.
Thank you. And a second.
I second.
Thank you, Michael. Any further discussion? All in favor?
Aye.
Erin, the 22-30, 300 Green Hill Road, I think you said Polson School, but is it the high school?
It's at Polson, but the high school they're the high school courts. So
Okay.
it's on the east side of Polson.
Thanks for that clarification. Okay, could I have a motion to schedule the public hearing for 22-30, 300 Green Hill Road to the January 19th, 2023 meeting?
I'll make the motion.
Thank you, John. A second?
I'll second that.
They should be doing pickleball courts.
I'm giving it to Jen.
Heard that.
Any further discussion? All in favor?
Aye.
Be a good meeting. Okay, thank you. And thanks for your guidance, Erin. Since Elliot had to leave, I think we'll table the approval of minutes until our next meeting. Do I need to make a motion for that, Erin? Can we
Yes,
just do
the January 5th meeting would be fine.
January 5th? Okay, so could I have a motion to table the approval of minutes for November 17th and December 1st, 2022 until our January 5th, 2023 meeting?
I so move.
I so move. Okay, good.
Shauna, you get it, and Ron, do you
I'll
want to
second.
Thank you. Any further discussion? All in favor?
Aye.
Okay. Remarks. I'd like to make a few remarks. First of all, we've received on December 1st, 2022, our resignation of Commissioner Shauna Hay, effective. This will be your last meeting, Shauna.
Oh,
We received it and it was approved by the Board of Selectmen. Shauna, we all want to thank you very much for your commitment to the Planning and Zoning Commission and 5 years of good service. We've appreciated your thoughtful and insights, and we will miss you. So thank you. Great meeting to go out on.
I have a, half an hour of remarks I'd like to make before. I'm
But
very
do it
much
at the
kidding.
party. Do it at the party. There's got to be a party, right?
I have just want to say I have really enjoyed sitting on the commission. This is something that is incredibly different than my day job, and really was such a privilege to learn about how planning and zoning works and how a town makes decisions about its development and its future. And to have been a part of that was, I feel it was a real honor. And getting to work with all the other fabulous commissioners and the amazing town planners we've had has been really, really great. So I know I leave the commission in very good hands and very capable hands. And I might pop in a meeting or two and, you know, maybe make some remarks at some point.
We would love that.
Maybe just come on just to tell you guys what a great job you're doing and
Always welcome.
how much we appreciate your service. So thank you everybody for allowing me to serve, and I will certainly miss seeing you every couple of weeks.
Here, here.
Yeah, thank you. And then looking ahead at our first meeting in January, we'll be holding the election of officers, which now include chair, vice chair, and secretary. Giselle Hagan will be reaching out to everyone through phone calls to see who might be interested in being considered and nominated, since we don't have a nominating committee for these positions. Erin, did you want to add anything else to the process?
No, this is a change in the new adoption of the charter that was effective in the beginning of this month, and the requirement to have a vice chair. And also now there's a term limit for serving as chair, which is 4-year max before you have to take a break. And the intent of the vice chair is that they would be the chair-elect moving forward.
Carol, does it seem like 4 years?
It seems like an eternity, but no, it's been great. It's been my pleasure and my honor. And Erin, just for clarification, though, I think even though the term limit is 4 years, we still vote every January, don't we?
Annual election, yes, but the max you can be elected for.
Great.
And that's starting this election.
2023.
This is the first election that the charter is effective.
Okay, thank you. Erin, do you have any other?
Just one, I received some additional information, some draft language for vision statement from our consultants for the POCD. So we'll be getting that information out to you shortly ahead of our meeting in January. And have a wonderful holiday, everybody. And we'll
Yes.
see you.
You too, guys.
Happy holidays, everyone.
Thank
You
you.
guys are great.
Could I have a motion to adjourn?
I will move to adjourn as my final act.
Let's vote it down.
Yes, you're right.
Second. We have a second. And all in favor?
Aye.
Aye.
Aye. Happy holidays, everyone.
Happy holidays. Happy New
We ought to
Year.
give people land and plans for Christmas.
Yeah.
Are we going to
Extra
meet
land.
in
Ron,
person?
goodbye,
starting in
Ron.
January or no?
Yes, we can do person.
We know that?
And hybrid.
Great.
Oh, so we're gonna do both.
Okay.
Okay. Thank
Bye.
you, Doc. Thank you.
Bye,
Doc.
everybody.
Thanks. Let's see.
What's that? Am I still in the Zoom meeting? I'm still in the Zoom meeting. Zoom meeting in progress. Why do I get go?